jury. I mean, I don't know. That's our other concern, but we'll deal with all that.
Yeah, I mean, I don't know why it needs to be in there. Again, they never lay eyes on the information, but it just, I tend to agree. I don't know why it's in there. Same with in count 2, where it says was inflicted upon any person, when first they say it's against the will of Nicole Oulson. Why do we have with any person, against any person in there?
Right. And I think and it gets cured. It puts, the purpose of an information is to put a defendant on notice, the accused on notice of what they're charged with, certainly by referencing the statute would do it, as opposed to putting superfluous language in there that potentially could cause not only confusion, but to get an outcome that's not just.
The 1020 life statute indicates great bodily harm or death. Like I said, I'd be happy to read their case law. If the case law is right on point, obviously, good faith, they could make that argument. However, that is the interrogatory, that is the language that's in the statute. I think our jurors are a little more sophisticated, that they're not going to be confused by that, and they're going to have all the facts.
All right.
What benefit does it give anyone great bodily harm on a second-degree murder charge? What benefit do we get that? It's not supposed to be there. I think you would agree. That's not supposed to be there because you can't have a second-degree murder with great bodily harm.
I'm quoting this the 1020 life language.
Right, I understand both your arguments. Always, you want to stick to the language in the statute when you can. But I certainly understand, I don't, I'll make that call later.
If it was a whodunit, it wouldn't be a problem, but
Yeah.
The language is.
Yeah. All right, are we ready to bring them in? Okey dokey, let's do it.
It's a lot of us, so
Yeah.
can they go ahead? Okay, very good.
Yeah, go ahead. They're probably getting pretty good at lining up by now.
I'm not sure if my email's working because I've got total silence. Usually Kaylee will send me a good morning.
Yeah? Huh.
I'm sure it's not.
Huh. Let me
I
see
asked
if
her, our old jurors here. And
no response. Uh-oh. Yeah, that's a good question.
Did you get an email from me? Oh, no, thank God, because I got the email that Reeves is down, and I'm like, I wonder if our email is down, and I don't even know it. Oh, okay. All right, and they're gonna bring them up now. Oh, no, okay, all right. Bye, not everybody's here.
Okay. All right.
Judge,
Yeah.
yesterday you mentioned jury number 51, was it?
Yeah.
Did you excuse me?
Yeah. Tina, it doesn't sound like they're all here yet, so it might take them a few minutes. They might, I don't know if they're gonna line them up anyways, or.
we brought a hotspot with us, but I
Oh,
guess we're gonna.
thank goodness,
I
because
think
this
we're
is
gonna-
typical.
Is it? So I think we're gonna bring in court tomorrow the hotspot.
Yes, yes.
Okay.
Judge, the one that they're missing is 2 minutes out from the courthouse, and we're gonna just wait.
Yeah, we better just wait.
Or you're gonna wait and just bring them all in at the same time.
Thanks. I'm using a little extra go this morning. Be seated, everybody. Good morning. Can you all hear me okay? All right, welcome back. Thank you all for coming. We'll jump right in where we left off yesterday. Were you all able to abide by my instructions during the recess? Excellent, thank you. Anybody have any issues they need to talk about first before we get started? Anything happen overnight or any changes that I need to be aware of? All right, I see no hands. Excellent. I think we were talking about special training when we left off last night, and I believe we were in row 3. Correct, Mr. Martin?
Yes, Your Honor, juror number 43.
Very good. You want to get started?
Yes, Your Honor.
All right, go ahead.
Good morning. Juror number 43. Yeah, there you are. Hi. We were talking about any type of specialized training being informal, formal. You recall the list. If you don't, I'll be happy to refresh your memory. But you raised your hand indicating that you had some type of exposure to that type of information. What was it on the list that you were exposed to? All the criminal? So constitutional law, criminal justice system, law enforcement?
No, not law.
Okay, and criminal law?
Yes.
All right. And how did you get exposed to that type of information?
I was paralegal in Georgia.
Okay. How long were you a paralegal in Georgia?
2 years.
Did you go to a special class in order to hold that position as a paralegal? And at that time, in Georgia, you were, as far as Georgia law and the criminal procedures in Georgia, constitutional law would be the same across the country. All right. Now, in the event that there's some procedure or law that is inconsistent with what you've been trained in Georgia, will you follow the instructions of the court and set aside that formal training as far as Georgia law and Georgia criminal procedure and follow the instructions by the court?
Yes, sir.
Okay. Regarding the constitutional law, is there anything specific about the constitutional law that was covered as a paralegal?
Not that I can recall, no.
Okay. Do you recall any of the information that you received about constitutional law?
No.
Okay. Thank you. Number 46, good morning.
Good morning.
And what topic were you exposed to?
Psychology and philosophy relative to self-improvement and biblical history.
Explain a little bit about the psychology regarding self-improvement. What does that entail?
Just to improve yourself based on your upbringing.
Okay. Was that a self-research?
Yes,
Okay, something you did on your own?
correct.
Okay. And the philosophy?
The philosophy was just based on how religion and the history of the biblical history interfolds between religions. It
Okay.
was based on taking a trip to Israel.
All right, very good. That it?
That's it.
Very good. Thank you. Number 47 in row 3. Yes, ma'am. Good morning.
Good morning.
And what information have you been exposed to?
I took psychology, sociology, and business law in college.
Was that a part of a general requirement to get a certain degree, either an AA or a BA?
Yes,
Okay, we all had to take certain ones of those to get there, right?
exactly,
So it was just probably one class, 2 classes?
exactly, yes.
Okay. Do you recall anything about those 2 classes that you're going to bring into the courtroom today?
No, but I've had some life experience with managing convenience stores, gas station, that type of thing, and had issues with
All right, and you felt that information that you received in those classes assisted you with that life experience?
Certainly.
Okay, thank you. Number 59 in row 3. Good morning, sir. And which areas have you been exposed to?
Some college courses in philosophy, and my degree is in religious studies, and I'm in ministry.
The philosophy class, can you give me just a very broad brush what that included?
There is intro to philosophy, there is ethics, philosophy of religion. I didn't go super deep, but I considered philosophy as a major for a little while. I never stuck with it, but it was pretty introductory.
Okay. Thank you. Number 60 in row 3.
I took counterterrorism classes.
You did what?
Department.
Right.
Counterterrorism classes.
I'm sorry, ma'am.
It's like sorry, I was a little bit late, so
That's,
I took,
relax, slow down.
I just like to know, I was trying to, I worked with the State Department, and I took counterterrorism classes,
Okay.
and they have the physical class, the psychological class.
That's within the counterterrorism?
Yes, we were getting ready. My husband was a diplomat in Australia, so I have to go through those classes.
Okay. Can you paint a broad brush? What is the physical part?
We were trained to use weapons and in case that we get kidnapped by terrorists, how to defend ourselves. And if we get kidnapped, how to deal with it.
Psychologically, how to deal with it?
Yes, and self-defense and how to use weapons.
Give me a broad brush. What was it about self-defense? What did that include?
Self-defense is in case that we get attacked, how it's like a little bit of martial arts.
Okay. Like I was talking with juror number 9, the grappling, the hands-on, the defensive against edged weapons, that kind of thing?
Yes,
Okay. Anything else, ma'am?
yeah.
All right, thank you, ma'am. Number 63. Yes, ma'am. Good morning.
Good morning. I took psychology, philosophy, religion for my degree.
And what is your degree in, ma'am?
Accounting.
Accounting? Okay.
And I was in the Army and I learned how to fire an M16.
Okay. When you were in the Army, did you do any of the basic training like we discussed with juror number 9 as far as the hands-on
No.
grappling, anything? Just the use of the long rifle?
Yes.
Can you paint me a broad brush about the psychology? There's so many areas that it can involve
It was just a basic.
Basic.
Psychology class.
just to get a degree.
Yes.
Yep, we've all had to
Yeah.
watch the rat in the maze. Okay.
And a religion class.
And a religion class.
Catholic college.
Okay. Thank you. Number 70, first time we've had to speak with you. Good morning. How are you? Good. What topics have you been exposed to, ma'am?
Concealed weapons permit.
Okay. We're going to discuss that in a little bit, and I'll make a note, and we'll come back and discuss it further. Thank you, though. Let's go ahead and go to row 4, number 65. Yes, sir. Good morning.
Good morning, how are you doing today?
Good. What topics have you been exposed to?
Well, constitutional law and contract law. I'm a sports agent, so I used to represent professional athletes.
Okay.
And my partner was a state prosecutor and a criminal defense attorney.
Your partner is or was?
Was. I'm no longer doing the sports agency.
Okay. All right, thank you.
Thank you.
Number 68 in row 4. Good morning. What topics have you been exposed to? Okay. Paint me a broad brush about the psychology. Basic class to get a degree, or did you expand it?
It's just the electives, basically.
The basic one? Thank you, sir. Number 71 in row 4. Good morning. And what topics are you familiar with?
In my bachelor's and master's level, just basic educational psychology. I was an education major for the master's and the bachelor's, so those were all education-based. But in my current role in my job, I oversee discipline and code of conduct for the school district. And so we do a lot of research into the differences between criminal law and educational law. So we oversee disciplinary hearings for students.
All right. Help me with the last part. I know there's some issues with search and seizure on campus and that sort of thing. Can you paint me a broad brush as far as the differences between the school district policies and criminal law? What is it that you're concentrating on?
Differences between reasonable suspicion and probable cause. So school-based administrators have, all they need is reasonable suspicion to be able to search a student, where law enforcement needs to have probable cause, things like that. And we do training of administrators on the differences of those types of things.
Okay, very good. Thank you. Number 75 in row 4. Oop. Number 77 in row 4. There you are, sir. What information have you been exposed to?
Psychology 101, sociology 101, and then we do a training at school, like how to react to situations non-violently, like when students act up, how to de-escalate the situation before they get to the point of like releasing their frustration on teachers and stuff like that.
Okay. The information that you get from the school system as far as dealing with the students and trying to either to de-escalate the situation, is that on a yearly basis? Is it a one-time thing?
So it's a 1 year, it's a one-time 2-day course, and then every year it's like a 3-hour refresher course, just on like how to do it, and then like moves to like, stop somebody from biting you or choking you and stuff like that, or them hurting themselves.
So actually physical contact?
Yeah, I mean, the whole point of it is to not engage in physical contact, but if you do, certain holds and certain ways to prevent them from hurting themselves or other kids.
Okay. Do you actually get to practice that as far as the de-escalation? Do you do mock scenarios where people are actors?
Yeah, basically, you role play a lot, like you're this student doing this, and then you're the teacher coming into the room, and, so it's basically a lot of role playing, and then practicing the physical moves with each other.
Okay. Thank you.
Yeah.
Number 81?
I didn't.
You didn't raise your hand last time, did you?
Earlier, I'm sorry.
That's okay.
A regular religion philosophy classes in college, and then I thought I was going to major in child psychology, so I took more than basic child psychology, but not very far.
Okay. As you sit here today, to what extent do you remember the information that you acquired during those classes?
Not very much, other than raising my own children and some of it, but not much.
Okay.
It's too long ago.
I don't remember anything out of my psych class either. Okay. Number 83. Good morning. What information have you been exposed to?
Mostly just religion. I grew up as a pastor's kid, so I was very heavily into the church growing up, and was taught a lot by my father things of just different religions.
When you say you were taught by your father, I don't want to refer to an in-home school, but because of the makeup of your family, this is something that you were exposed to?
Correct.
All right, and it was part of your lifestyle as far as the church community and the home community kind of coexisting.
Correct.
And through that life experience is how you became familiar with the information that you have. Okay, thank you. Let's go to row 5, please. Number 86. No, there you go. I'm sorry. Number 86, good morning.
9 credit hours in ethics and religion, psychology, the same training that gentleman had with the public school system.
Okay,
Because I taught him adaptive classes. And I took a constitutional law class 25 years ago, 30 years ago,
all right,
that I don't remember much about.
okay,
There are 10 amendments.
okay. How did you either choose or had to, or was however you got involved with the ethics and religion?
College that I went to required 9 credit hours.
Okay.
So it was forced.
All right. We've all taken those classes. Okay. All right, now let's go to, thank you, sir. Now let's go to row 5. Number 87. Good morning. Could you just flip your placard for me? It looked like 7. It was upside. There you go. All right. What information have you been exposed to, ma'am?
I was a behavior analyst.
Speak up just for me.
I was a behavior analyst, a behavior specialist for Pasco County Schools for a number of years.
All right. Paint me a broad brush. What do those duties include?
Basically looking at kids with behavior issues and trying to determine the function of the behavior.
The function of?
The function of the behavior,
Okay.
so that interventions could be developed.
Okay. Now take me to the training for that behavior specialist. Was that provided to you by the school system? Was it some type of institutional, university, college class that you had?
Both.
Both?
You know, there was ongoing in-service with the district and classes I took at the college level.
All right, very good, thank you. Number 91.
Mine's for later, concealed.
Okay, thank you. Number 92 in row 5. Good morning, sir.
Morning.
And what topics have you been exposed to?
Psychology for the University of Houston, religious studies, weapons, and self-defense.
All right, I'm going to go backwards. The self-defense and the weapons, is that combined or 2 separate things?
2 separate things.
Well, let's talk about the self-defense.
It's ongoing training through the airline. And there's also a separate class that I take that is actual physical, not just discussion and theory. And that's offered through the Minneapolis Airport Commission.
Through the what?
Minnesota Airport Commission, the MAC.
Okay. And this is because you're a commercial pilot?
Yes, sir.
And all the scenarios would be involving that particular environment?
That's where the gist of it comes, but the hand-to-hand is just in the as well. Transportation to and from, lodging, through the airports, that kind of thing.
Okay. As far as weapons, are you allowed to carry a weapon on the airplane?
I'm not an FFEO.
Okay.
I participated in the Federal Flight Deck Officer program.
Okay, so what training as far as the weapons?
Sidearm, rifles, crew-served weapons,
What kind?
crew-served weapons. Any weapon that requires more than one person to operate.
Oh, crew. Okay. The religious and psychology, was that part of your college or something that you elected to take?
that started in the Army. Some of the deployments, we needed to understand the religious makeup of the countries that we were going into and how that related to our interactions, and just personal study through today.
All right, very good. Thank you, sir. Number 93. Good morning, ma'am.
Good morning.
And the information you've been exposed to?
Just 1 year of basic intro to philosophy, sociology, and religious studies.
Okay. Anything about those classes and the information provided that you recall today and you would bring into the jury room?
Just basics of psychology, since I went on to do a master's in human resources.
Okay. And as far, what was the theme of your master's?
Human resources.
Human resources. Okay. All right, thank you. Number 96 in row 5. Good morning, sir. What information have you been exposed to?
Penal law, criminal procedure law, law enforcement, weapons, unarmed defense tactics.
All right, let's start from the beginning. Penal law, paint me a broad brush. What does that include?
I'm a retired New York State correction officer, and that was all part of our initial training with the penal law, with the Article 35, gives us the right to introduce force.
The use of force report? All right. Did you take specifically have in-service training regarding the guidelines and policies of use of force within the correction system?
Every year.
Okay. In that study, did you become aware that within the Department of Correction, the use of force standard is different than outside the prison?
Yes.
Okay. Now, having acknowledged that, your training under the 8th Amendment that you learned about for Department of Correction, can you kind of set that aside and listen to the instructions from the court?
Yeah.
That's not going to be a problem, right?
No.
No, okay. As far as defensive tactics, paint me a broad brush on that.
It's all basically unarmed defense tactics. Didn't deal with a lot of weaponry, with the exception of homemade broomsticks and hot buckets. And
Those can hurt you too, right?
exactly, but it was unarmed defense training, and also with the use of batons.
And what?
And the use of batons.
Use of batons. In that training, was there any training dealing with the de-escalation theory part of defensive tactics, that component of defensive tactics?
You were always taught to try to de-escalate before you always have to put hands on.
Okay. Thank you, sir. Number 101, I believe you'll be our last one. Number 101, there you are, ma'am. Good morning. Speak up for me and tell me what topics you've been exposed to.
Basic topics for a bachelor's degree.
Okay, the psychologists, those that we all have to do.
Right, and the religious stuff is just on my own.
Yes, ma'am. Okay. Is there anything about those basic courses you took in college that you recall specifically that you're going to bring into the jury room if you're selected?
Not that I recall.
Okay, very good. Thank you. What I'd like to do now is go back to the questionnaire, relax, and talk about a couple of things. I'm not going to talk to everyone, but I need to kind of fill in the gaps. as far as the occupation, right? I know putting retired is what you do now, but I kind of like to know what you did then, okay? So let me go through a couple with you, bear with me, and let me just complete a little bit more information on the questionnaire. Let's start with, in row number 2, number 29. Good morning. I have that your spouse is a JCC contractor. Are you employed outside the home, ma'am?
No.
Have you ever been employed outside the home?
Yes.
And when you did have that occasion, what did you do?
I was a case aide for nonprofit company, Community Aging and Retirement Services.
Tell me what the duties of that position is.
Mostly it was ordering supplies and meals and stuff for the people, retired people that needed it. A lot of paperwork, billing, that type of stuff, talking to the clients.
Were you in a supervisory capacity at all?
No.
Just yourself?
Yes.
How long did you do that?
6 years.
All right. Any other employment outside the home other than that?
Before that, I worked for a medical company,
All right, and what did you do for them?
just ordering medical supplies and, for the clients and everything.
Supervisory role?
No,
Anything before that?
that was all of it.
That was all of
Way
it.
back.
All right, very good. Thank you so much. On road number 2, number 31. Where's number 31? There you are. Good morning. You indicated that your spouse was retired. Are you employed at this time, sir?
I'm not, I'm retired too.
All right. So that's retired. So now we're back to before retirement. What did you do for a living?
I was an IT project manager,
Explain to me what that is.
various projects in our organization on the IT side that needed to be implemented either due to internal or federal HIPAA guidelines.
Okay. Now, the HIPAA guidelines is setting up a system that is secure. Would that be correct?
Healthcare guidelines, not just security.
Yeah, healthcare guidelines. All right. Did you write the programs, or did you simply install the equipment, install the applications, and keep them running properly?
Originally, I was a programmer, so, myself, I wrote code or installed code. As a project manager, I was in charge of anywhere from 6 to 15 people roughly, depending on the scope of the project that we had.
Okay. And how long did you do that, sir?
20 years.
Any other position before you held that job?
My IT career as a programmer early on, working your way up.
Okay. As far as writing the programs themselves, what kind of programs were you writing? Way back when, I know it was the early stage of this, and it's come a long way.
Yeah, most of my career was on the healthcare side, so
Okay.
it was claim processing, we used to call them encounters at one time, membership processing, that type of thing.
Very good. Thank you, sir. In row number 3, number 44. 44. Oh, I'm sorry. My bad. Number 46. There you are. I have it down as business manager, but I'm asking you to expand that just a little bit for me. Of?
That's several different. You want from the beginning and then to the end, would that be the best way to do it?
Sure, just bullet them out for me.
Okay, I was a manager for a dental assistant in my younger years, involved in the association. real estate, became a broker owner, and did some continuing education for real estate for the state of Ohio. And then I was a business manager of a cell phone business with my ex-husband. And then I became a business manager for a facility that we built for a veterinarian and built it into a 5-veterinary practice, over 40 employees and 5 doctors.
And an eye doctor?
Veterinarians.
Oh, okay. And the last one was with the veterinarian?
Correct.
Okay. Is that something you started or you're employed?
I was employed.
Okay. Let's just do the last one. As far as the business manager of the veterinarian office, paint me a broad brush. What are your duties?
My duties was for handling all of the accounting, income, profit, all of the legalities of the OSHA, anything relative to employees, to make sure the company and the business was functioning in a legal capacity for safety from all aspects of the business, the building, maintenance of the building, improving the business and in all aspects of the business.
And how long were you with the veterinarian office?
5 years.
5 years.
Oh, no, excuse me, 7 years. It's 5 years since I've been retired.
Very good. All right, thank you. Continuing on row number 4, number 67. Where's number 60?
I'm here, sorry.
That's all right. Do you work outside the home?
No, sir.
Have you ever worked outside the home?
Yes, sir.
And what did you do?
With the Pasco County school system, I worked in the clinic.
And what did you do in the clinic? What was your duties?
I was a clinic assistant, so when the kids came in sick, I had to take temperatures, vitals, or let them call home. It was pretty much high school, so.
Okay. Did you have any formal training, CNA, RN, anything like that? You know what I'm talking about, any type of degrees to hold a position?
About 30 years ago, I went to EMT school.
Okay. Did you actually have an occasion to work as an EMT?
I worked as an EMT for a company in Alabama. Yes.
All right. And how long were you doing that job?
Probably for about a year when my husband got transferred to Tennessee, and we lived in Tennessee for 10 years, and then I worked with the school system in Tennessee.
All right. In the clinic, using your EMT skill?
In the clinic, I was a substitute teacher, and I worked in a class with handicapped children.
All right. In order to perform that duties, did you have any specialized training to be a substitute teacher, especially with that specialty? Did Tennessee require anything for you to
Not
hold?
at that time.
Okay.
I think it was when we left Tennessee that, they came.
Yes, ma'am.
To be an assistant if they wanted more.
Very good. Thank you. Number 68. Where are you? There you are. Former law enforcement? Military. All right. And I believe we talked about that, and your current occupation is where?
Walmart distribution.
And how long have you been with Walmart in distribution?
5 months.
5 months?
Yes, sir.
Prior to that, were you employed as a civilian?
Yes, sir. I worked for a mowing company.
Okay. And how long did you do that?
2 years.
And before that, did you do anything in the civilian world?
I worked for another mowing company.
Okay. Take me one more. Before that, were you military or?
Yes, sir.
All right, very good. As far as working at Walmart and distribution, are you in the warehouse, or are you actually, tell me what your duties are. I'm trying to, there's a lot of things you can do in distribution. Tell me what you do.
I'm an unloader, so I'm loading trailers, and then I work part-time in automation.
In Walmart?
Yeah, we have the giant robots.
Oh, right. All right. Do you program them, service them, or just make sure that they're doing their job?
It's called feeding.
It's called what?
Feeding.
Okay, tell me what that is.
Put freight into the
Okay.
robot.
Very good. Thank you, sir. Number 70. Good morning. Do you work outside the home?
Not anymore.
All right. Did you ever work outside the home?
Yes.
All right. And what did you do, ma'am?
I was administrative assistant at the Dade City Hospital and in Zephyr Hills Hospital.
Explain to me what your duties would be as an administrative assistant.
Basically, it's a glorified secretary. You answer the phones, you do the mail. I work for the CNO, so whatever she needed for the nurses, then I type them up or whatever and handle policies and procedures and.
Well, let's talk about that. When you say handle policy and procedures, are you reviewing them and writing them, or just?
No, they do that and I make the corrections that the CNO needed done.
Very good. And how long did you perform those duties?
13 years.
And before that, did you have any other employment?
I worked at East Pasco as a insurance collector for Medicaid.
And what are the duties of the function of an insurance collector?
Trying to get money out of the insurance company to pay their bill.
Okay. Thank you, number 70. Number 77? There you are, sir. Help me out with your occupation. I know you're married. Are you employed now?
Actually, I'm single, unemployed.
Single and unemployed.
No, I'm employed.
I had it all wrong, didn't I?
Sure you got the right number?
Well, let's just go for it.
All right, so I'm single, I'm employed.
Where at?
Well, I have a bunch, right now I'm working at Seven Oaks Elementary School as a PE teacher. I also referee ice hockey games at night.
All right,
I've worked like every single job known to man.
all right. How long have you been a PE teacher?
That's the only one that I've kept a while, 18 years now.
Okay. And refresh my memory, what grade level? Of what?
K through 5.
K through 5. Any specialized formal education or training in school to be the PE teacher there?
No, just the college degree.
All right, and what's that in?
The first one was sports nutrition and fitness management. The second one was phys ed.
Very good. Thank you.
You're welcome.
Row 5, number 87. Good morning. I see that you're retired.
Yes,
Prior to retirement, what did you do?
I was a behavior specialist. I was a behavior specialist for Pasco County Schools.
I think I've had a discussion about that.
Yeah.
Same job?
Yes.
All right. So we're talking about intervention and how to correct whatever problem we're trying to intervene.
Right.
Okay. Very good, thank you. Okay, I think we've caught up a little bit with that. Thank you. Yep, we're good. Let's talk a little bit. We're going to change topics just a little bit here. We're going to try to do some group discussions and move things along a little bit. So please, everyone, listen up. We're going to go kind of row by row, maybe even as a group to see where we're at. I'll jot down your numbers and we'll talk. But let's talk a little bit about your role as a juror. We're going to discuss several things now dealing specifically with what we're asking you to do. And as I mentioned before, we all realize that we all bring different attitudes, idiosyncrasies, skill level, education. We're all different. And some of the things that may be a problem for some people is expressing ideas in a group. You're fine maybe one-on-one, a casual conversation, but if you're in a group, you're just kind of clam up and you sit there and you don't say anything. It might be because you're shy, afraid to speak, don't want to be wrong, don't want to be criticized. It doesn't matter. But that's what the jurors do. The jurors are called upon to, as a group, to collectively and individually express your ideas, and then you make your decision based on after the discussion. So it's important that not only you listen to the other jurors, but they have an opportunity to get your input so that everyone can make an informed decision, whatever that might be. So my question to you is there anyone, and this is going to be a group, I'm just going to show of hands, is there anyone that once they get into a group and have to express what you think, you have a problem with that and maybe struggle doing that? Is there, let me just see a show of hands of the whole group, a paddles up, and I'll write down numbers. Does anyone have that problem? Great. I see no show of hands. Thank you. In deliberation, you'll receive some instructions and guidance about how you're expected to conduct yourself within the jury room, and you'll get those from Your Honor. I want to discuss with you what is not appropriate. It's not appropriate to talk about the sentence, what you think it might be, or even have that come up in conversation. You are the fact finders and the law appliers. That's your job. Her Honor has her job. You do your job first. Her Honor does her job after the verdict. It's important that that type of thought process and to make a decision on what you anticipate Her Honor might do is just not appropriate. So let me ask you this, and I'm going to go row by row, because that's how important this is. First row. Can each of you be the fact finder and the law applier and keep out of your discussions whatever potential sentence might be? Row number one? All right. Same question with row number two. As a juror, can you be the fact finder and the law applier and keep any type of discussion about sentencing out of the equation in your verdict? Row number two?
Yes.
All right. Row number three, same question.
Yes.
Row number four, same question.
Yes.
Row number 5, same question. And finally, my last two and 6.
Yes.
We touched upon it briefly in our last discussion about what your role is in following the instructions of the court. Her Honor, at the beginning yesterday of voir dire, talked about following the law. And as the jurors, you will receive the instructions by the court, and based on those instructions, that's what you're supposed to follow. All right. Number 9, in your mind, how important is it for you to follow the law in this case?
Very.
All right. Number 18,
That's the core of my belief system.
very important, right? Number 43, how important is it to follow the law? Very important.
Very important.
Number 92, how important is it for you to follow the law?
Paramount.
Does everyone agree with the other panel members that it's paramount that you follow the law? Everyone agree?
Yes.
We've talked about how we're all individuals, and I keep saying this over and over, but we are, and that's why we ask these questions to see, because of your personality and life experience, are you the right fit for this case? And we just got through talking about following the law, and you all said it was paramount. There are some life experiences and beliefs that you hold that you might be struggling with, and some of those might be on a ethical or religious spectrum. And I've noticed a lot of people on the panel have had some sort of exposure to some type of religious studies, ethics in religion. We have a minister on the panel. And there's a lot of teachings in all the different religions that you may be involved in about sitting in judgment of another. And so that's what I want to talk to you about. Is there anything in your background, now that I've talked about it, we've talked about following the law, rendering a verdict, is there anything in your mind now, based on your training, your upbringing, that you're going to have a problem sitting in judgment of another? Row number 1? Row number 2? Row number 3? Row number 4? Row number 5? And number 6? Everyone's no? All right. Yeah, that was a trick question. You need to say yes or no, right? All right. We're going to continue our discussion with following the law. The law given to you by our court, Her Honor read you the standard of proof in this case, beyond a reasonable doubt. That is the standard, and it's the state's burden. It's a burden that the state gladly accepts. It is our burden, no one else's. It's our burden to prove this case beyond a reasonable doubt. All right. The definition of reasonable doubt in detail, Her Honor will give that to you again before you go deliberate, but you heard it yesterday. When you think about reasonable doubt, what the proof is, well, what does that apply to? The court will give you instructions about the elements of the crime of second-degree murder and aggravated battery. She'll give you that. But the burden applies to the elements of the crime. That's what the state has to prove. So let's just do a crazy hypothetical, okay? Say this, if you kind of think of the elements as kind of like building blocks, that's what we have to prove. We have to prove A, B, and C beyond a reasonable doubt. Because once that is proved, then you make a determination of guilt or innocent. Let's say that there's a wedding, okay? And in order for the state to prove that a wedding occurred, it was just two elements. There was some notary there that said some official words, and then the couple, both of them said, "I do." That's all the state had to prove. But there was a wedding, and we're going to bring in witnesses. You know, at the wedding, there's more than just a bare room and an official and two people. There could be other guests, there could be cake, there could be weather conditions that occurred that hamper things. A lot of things can go on. All those other things, the state doesn't have to prove beyond a reasonable doubt. We don't have to prove beyond the reasonable doubt it was sunny that day, or that there was cake, or that the bridesmaid wore a pink dress. So the only thing we have to prove is a notary said some official words, and two people said, "I do." All the other stuff is the environment that took place. Row number one, the little silly, I guess, example that I gave you, does that help you understand how the reasonable doubt is to be applied to the element case? Do you all understand that on row number one? Yes. All right. Row number two, you understand it's just the elements of the crime. Row number two? Yes. Row number three? Yes. Row number four? Yes. Row number five? Yes. Yes, all the way over? And number six? Yes. Okay. This particular case, you heard the charges, they were read to you. It is second-degree murder and aggravated battery. And you know from the information that was read to you that as far as the second-degree murder, someone was killed. And from the aggravated battery, you know that someone potentially was harmed physically. And those are the two crimes. We've had some discussion about your life experiences leading up to today. But I need to ask you, just based on the charges themselves of a death and a bodily injury, is there anything about your life experiences, now that we've talked about everything, that you feel maybe this just isn't the right case for you? Let me give you an example. If this was a DUI manslaughter where someone was killed by a DUI driver, and in your life you had a family friend or whatever that was killed by a DUI driver, and that just upsets you, maybe that particular manslaughter case wouldn't be the right case for you. So that's why I bring it up. Sometimes we just have that nagging feeling that this isn't good. So let me ask row number one, is there anything in your life experience, just based on the charges themselves, that you feel maybe you're just not the right person for this case? Row number one? No. Row number two, say it out loud. No. Row number three? No. Row number four? No. Row number five? No. And the last two and six? No. Thank you. We spent a couple of days selecting, narrowing down, if you will, the last almost 50 people that have been in the courtroom yesterday and today. Part of the problem was the publicity. The case is, in fact, 8 years old, as you know. The incident occurred in January of 2014, and in this particular case, it did take some time to work through the system, various reasons. Legal reasons, pandemic reasons, the voluminous nature of the case. So my question to you is, because of the age of the case, is there, and I'm going to ask this as row by row, is there anyone that's going to hold either the state or the defense responsible for the delay in the case, and that having a negative impact on how you view and judge this case? Anybody on row number 1 have that feeling? All right. Row number 2, you're not going to hold anyone, quote, responsible for the delay and have a negative impact on your deliberations? No? Row number 3?
No.
Row number 4? Number 5? And number 6? Thank you. We've been talking about the role of the juror a little bit, the procedures that are going to be involved, your role as jurors, what you do in the jury room. You will get instructions by Her Honor regarding the evidence and how, some guidance on how you can conduct an analysis of the evidence that has been provided to you. And you'll probably hear during this trial some evidence that's in conflict with one another. You'll get a jury instruction on that. As a juror, it's going to be your responsibility to resolve whatever conflicts you feel exist within the trial, either between the testimony or the evidence. Determine how, based on your determination of how you resolve those conflicts, what facts you're going to eventually rely on, and returning your verdict. But you have to go through the analysis. So let me talk, first of all, who has a teenage child at home? Okay, number 13, she was the first one up. So number 13, with your teenager, have you had an opportunity to have to resolve a situation involving conflicting information, like I was supposed to be at Johnny's, but I was really at Billy's playing basketball, something like, have you had an opportunity to do that?
Yes.
Okay. How'd you go about resolving that conflict?
Asking additional questions and putting the pieces together, recognizing when information doesn't make sense or there's a gap in the story, and leaning in and asking more questions, which is pretty easy to do with a teenager. You can typically get to the story.
Okay. The rest, did everyone hear what she said? And let me see a show of hands of who also has a teenager at home. Would your response be about the same, that's the way you do it?
Yes.
Okay, all right. Who's been to a Bucks game? Oh, first one up, number 86. Now everyone's going to be looking at the shoes when I ask those questions, right? Number 86, you've been to a Bucks game?
Yes.
All right. When you're sitting there in the stand with 50,000 other people, you got people next to you, are you looking around, seeing everything that's going on?
Occasionally. Yes.
All right. Are you watching the game?
Yes.
Are you always watching the game?
Not always.
All right. would you agree or disagree with me that even though you're at the same event, your attention may be directed one way or another away from the game, and you would not see portions of the game?
Yes, sir.
All right. Would you agree or disagree with me that just because you didn't see some portions of the game, that doesn't mean the game didn't occur?
Yes.
Okay. Number 5, let me just ask you a couple questions, all right? Is it also your life experience that individuals can perceive and have an opportunity to see an event, but because of the environment they're looking around, they may not see it all? Is that something that you have the life experience around?
Yes, sir.
That does occur?
Yes, sir.
Okay. Because of that phenomenon that we just talked about, is there anyone in here that does not believe that individuals watching the same event are going to always come in and say exactly the same thing? Does anyone believe that? Let me see a show of hands of anyone that believes that. I see no show of hands. Number 9, would you agree or disagree with me that people would have a different perspective depending on location, attention span, interruptions as far as perceiving event, and 2 or 3 people may come in looking at the same event and have different information? Yeah. In fact, would you agree or disagree that that information could also be in conflict? Yeah. All right. Let's go back to that silly example that I had, okay, about the wedding. We got the wedding going on, and we have the, let's call him Bob, let's not give them names. We have a couple that are getting married, and that's what the state has to prove, that this couple was in fact married. Now, there were witnesses there. They're sitting at different locations, some up front, some up back, some to the left, some to the right. Some attention spans of some people are not that great, others are very specific. Some people are handling children and are distracted, but they're all sitting here at this event. And then we ask these people to come in and we say, okay, tell us what happened at the wedding. And there's some conflicting information. There's information that say, well, some people say the flower girl dropped the basket, and some people don't recall that. You might have whether or not the best man had red hair or blonde hair. There was a conflict. There was how many members of the bride's party were there? Was there 3 or 5? There's just a conflict there. Was the groom taller than the best man? Okay. The proof would be, were 2 people married? But when you bring the people in, they say 2 people were married, but these details about the wedding, let me ask, I'll go back to, where's number 29 on my second row? There you are. Would you agree or disagree with me that those factors about whether or not who was taller or shorter, how many bridesmaids were, in that party, whether or not the flower girl dropped the flower basket, who had red hair and blonde, those things in conflict have nothing to do with 2 people, whether or not they were married. Would you agree with that?
Correct.
Okay. And if that was in this make-believe case, and that was the state's burden to prove that 2 people were in fact married, that was the only element, but you heard all this other conflicting information about what's going on around. Now, let me just ask you, hypothetically, would you believe that the state proved its case or not prove its case?
With all the evidence and.
Yeah, the elements would be just 2 people are married.
Right.
But you heard all this other stuff.
It's hearsay, the other
All right. Okay. Let me ask, where's number 33? There you are. In that hypothetical situation where the state's burden is only those two things, there was people married. Official said some words, two people said I do, but then you heard all about the ceremony and all the conflicting information about that. All right? But the only thing the state has to prove, beyond a reasonable doubt, is two people were married. All right? Now, knowing that some information is in conflict, hypothetically, would you believe that the state met its burden or not met its burden? All right. Would you agree or disagree with me, but the other information is just immaterial to the elements of the case? Whether or not the flower girl dropped the basket has nothing to do with whether or not two people were married, right? Correct. All right. I know we've used some silly examples, but let me, by a show of hands, does everyone understand conflicting evidence and your role as how you resolve it and look at it, and if there is conflicting evidence, you determine, does it impact, has the state proved its case beyond a reasonable doubt as far as the elements? Let me show you. Does everyone understand that now? Everyone? And you say all the paddles up. Everybody up? All right. There we go. Thank you. Next one's going to be a little long. What do you want to do?
Well, this fell over an hour. I don't know, if everybody else is like me, you might have drinking an extra cup of coffee this morning and probably use a break. So let's go ahead and take a 10-minute recess, just head back to the jury pool room and be ready to line up again. Remember my instructions during the recess. Thank you. them? We ready for them?
Carrie, can you go ahead and bring that through? They ought to know by now, but.
Thank you. Were you all able to abide by my instructions during the recess? All righty. We'll get started again. Mr. Martin?
We're now going to discuss the topic that might take just a little bit. Based on my experience with you yesterday, when I talked about training and firearms and defensive tactics, just about everybody's hands went up. So I'm going to try to organize a little bit, because as you know, in this case, there is in fact a firearm that was used. And so we need to talk about that particular issue. I'm going to do this row by row, just because I think that'll be easier for everyone to keep it organized. So what I'd like to do, and I'll do this for each row, I'll go and ask you whether or not you own a firearm and have a CCW. And then whatever row we're on, raise your paddle, write down your numbers, and then we'll just deal with row by row. Okay? Everybody's paddled up. I couldn't see a lot of them. So let's try that procedure and see how we go with this.
Can I ask a clarifying question?
Number 71.
Is it personally or in your home? Own a firearm personally or in your home?
Let's include in your home. All right, thank you for that clarification. Okay, we're going to talk about experience with firearms. As you know, a firearm is involved in this case. I'd like to discuss with you a little bit about that, so that all the attorneys in this room can make a determination whether or not you're the right fit for this case. That's the reason for the inquiry. And I like to do it row by row. So just row number one, if you have a CCW, you own a firearm, or there's a firearm in your home, just put up your paddles, and I'll write down the numbers. 2, 5, 9, 13, 18, 19, and 20. Okay. Let's start with number 2. You have a CCW?
Yes.
Okay. There's a process in order to obtain it. You first have to get a certificate and have instruction by someone that's in the statute, recognized, and can provide the training. And then once you have the certificate, you fill out the form for the background check, and then you mail it in with your fee, and then you get your license, right?
Yes.
All right, so I want to start with the first process. When did you get your training? What year?
Probably about 3 years ago.
All right, so this would be 19? Okay. And where was your training?
Sumter County.
There's several types of training that can go on. There can be an NRA course they have that you can take by an NRA certified instructor. You can be taught by someone who is certified by the Florida Department of Law Enforcement as a firearm instructor at a police academy. Or you can just have your own law enforcement experience, and that'll qualify. So what type of instructor did you have?
The law enforcement.
And how many hours was it?
3 or 4.
Okay. During that time period, were you required to fire the firearm more than once?
Yes.
You got your certificate?
Yes.
And now you have your license since approximately 2019? Yes?
Yes.
Okay. I'm going to cover that process with everyone, then I'm going to have some general questions, all right? Number 5? All right. When did you receive when you got your training? What year?
From 1996 to 2016, it was a yearly requirement, military combat arms training.
All right. And then do you have a CCW now?
Yes, sir.
When did you start? You were allowed to rely on your training in order to make the application. So what date did you make your application?
2018.
Okay. And that was because you were out of the military?
Yes, sir.
All right. And what type of training? You heard my question.
Yes, sir. Is yearly training,
No, as far as the CCW.
as far as the CCW, it was military training.
Okay. And then, right, okay. So it's been, what, 3 years?
Yes.
You've had it? All right. Number 9, just the CCW application. Did you have to do training before, or did you just file an application?
No, I did training before,
All right. And what type of training?
law enforcement.
Okay. When you say law enforcement, if you were in law enforcement, were you?
No.
No.
By law enforcement.
Right. So when you say law enforcement, was that individuals certified by the Florida Department of Law Enforcement to be a firearm instructor? Is that type of law enforcement you're talking about? Okay. So you had that individual. And when did you complete that training? What year?
2012.
All right. And then you applied and have received your CCW? And you've had it since 2012?
Yes.
In 2012, was it 5 or 7 years? Did you renew it?
Yes.
All right, so that'd be 2019, you renewed it?
Yes.
Okay, that's what I was trying to get at. Number 13, let's talk about the process. When did you take a class in order to get the certificate?
The first time I took a class was up in New Hampshire, I believe around 2010.
Okay, and I'm sorry, I'm not familiar with the requirements in New Hampshire. Is there a particular instructor that has to do that pursuant to a statute, or is there even a class?
Yeah, it was a class. I believe, if I remember correctly, it was a retired law enforcement person who held the class.
All right, and in that class, were you required to fire the firearm more than once?
Yes.
Now, in 2010 in New Hampshire, now you're in Florida. Did you do the necessary paperwork to transfer it, or are you just rely on the
No,
reciprocity?
I took a new class in Florida.
Okay, when did you do that?
2020, I believe.
Okay. And same question, the instructor, NRA?
The instructor was a retired law enforcement
Okay,
person.
all right. So you've had yours for 11 years then. Number 18.
Yes, I was instructed by 3 federal agents with Homeland Security.
Okay, and what year did you get your certificate?
In 08 around. Discharged probably 400 times. We have a firing range on our property.
There you go.
And I have a better shot than my husband.
All right. In 2008, your 7 years or 5 years, did you renew it?
No,
Do you still have your CCW?
no, I don't carry.
All right. When did you, so in 2008, was it a 5-year license or 7?
I don't even remember.
Okay, but you do not have one now.
I do not. I kind of have a bodyguard with me all the time, so.
Okay. Number 19.
I had my license from 98 up until 2020 in the state of West Virginia.
All right, let me just talk about that real quick. Not familiar with the requirements. Is there a statutory requirement for training before the application?
Yes.
And what type?
A certified instructor from law enforcement.
Okay. All right, and when you moved to Florida, are you relying on reciprocity, or did you get a CCW here?
No, I haven't applied for the state of Florida yet.
All right, but is your West Virginia CCW still valid?
It is expired.
Okay. Do you plan on an application to Florida, or are you done?
If I get time.
Very good. Number 20, when did you start the training to get your 08?
Yes, sir.
Type of class, NRA, or,
I believe it was retired law enforcement officer.
okay. In that class, were you required to fire the firearm more than once?
Yes, sir.
I don't know in 08 if it was 5 or 7, so did you renew?
It was, I believe, seven or eight, actually, and yes, I did.
Okay. So you have it now?
Yes, sir.
Okay. All right, let's go. Yes, ma'am, number 15?
Sir, before you proceed to the second row, I did also get my training, my military training. I was under the impression that if I had my concealed weapon license, which I don't, but I do have training handling a firearm.
Okay. All right. Right now, I'm trying to get through the CCW people, but you do not have that license in the state of Florida?
No, sir.
Okay. We're going to get to just general ownership in a minute. Let me just get through this process. But thank you for bringing that to my attention. I appreciate that. Okay, let's go to the second row, please. Let me see the paddles on the second row. Everybody, I'll give you a few minutes to get up. So I have 2 on the second row, 29 and 31. Let's start with second row, number 29. You understand the questions, starting with the application process, training. Would you?
My husband.
Husband, very good. When did he get his training? Do you remember? How long ago?
Whatever the state law is, I'm not sure.
I'm not sure what that means.
Florida, I don't know when you have to do that, how long it is.
No, ma'am. Do you know when he first?
Every time it's due.
I understand that, ma'am. When did he first get it?
Oh, probably about 20 years ago.
Okay. Okay. And he's been renewing?
Yes.
And you do not have a CCW?
No.
Thank you. Number 31, when did you first do the training so that you could get one?
I think it was 2018 in Minnesota.
All right. Before we jump into Florida, as far as in Minnesota, was there by statute, a specific instructor that you had to do training or no training?
Training, and I think it was ex-enforcement.
All right. And in Minnesota, did you fire the firearm more than once?
Yes.
Okay. Now, 2018, that was in Minnesota. Did you maintain that license and relying on reciprocity in Florida, or did you apply for another one here?
At that time, there was no reciprocity, so I'm currently licensed in Minnesota to Arizona. I want to say it's Utah and in Florida when we moved here.
So you do have a CCW in Florida?
Yes.
And so in 2018, when did you get the Florida one? What year?
I think it was the fall of 18.
Okay. All right, thank you. Row number 3. Row number 3, we're just talking about CCW and the application process. All right, in row number 3, I have juror number 60. Anyone else? And 70. Let's start with juror number 60. The process, when did you first start?
2020 at the Shooter's World.
Okay, that's where you got the training?
Yes.
All right. And you got your certificate?
Yes.
And now, did you make the application and currently licensed?
Yeah, I got it.
Okay. Number 70,
2002.
Florida?
Yes.
And what was the type of training? NRA instructor or law enforcement? Okay. Were you required to fire the firearm more than once? Right. Did you renew after expired? Is your license currently current? Thank you. Row number 4, we're just talking about the CCW and the application. Let me take a quick look. 65, 75, and 86. Let me start with juror number 65. Remember, just the application. When did you first apply for, in any state, I guess now, I should have done that.
West Florida, I believe it was 2013.
Okay. The type of training?
The
And in that training, were you required to fire the firearm more than once?
I believe it was only once.
Did you renew your license?
Yes, I have.
And you're current?
Yes, sir.
Thank you. Number 75?
2010, NRA, one time.
One time? Okay. Did you renew it?
Yes,
And you're current?
yes, sir.
Thank you. Number 86?
2013, law enforcement officer, and I did not activate it. I did not turn it in to the courthouse.
All right. So you did not, you did the training, but you didn't submit the application.
I shot more than once, did not turn it in.
So as of right now, none.
Correct.
Got it. Thank you. Let's go to the fifth row, please. You see your paddles on the fifth row? Hold them up a little bit higher. There we go. We have 91. Anyone else on the fifth row? All right. As far as the application itself, when did you first do that?
A year or two ago.
All right, so this is just now 2021, so we're talking 2019, 18?
19 or 20.
Okay. Type of instructor?
Retired law enforcement. I shot it once.
Okay. And did you submit, I guess I should have asked, did you submit the application, but did you submit it?
Yes.
And you're currently licensed?
Yes.
And row number 6. I see no paddles.
There's someone.
109?
Yeah, I was just gonna say, I'm not licensed, but my father is.
Okay. All right. Well, let's just talk about that just for a few minutes. All right. Were you aware when your dad first became licensed?
Yeah, that was probably maybe 10 years ago.
Okay. Do you know whether or not his license is current?
It is current.
All right, very good. Thank you. Now that we've gone through the licensing process, then the general question is, and we're going to take it row by row, and I'll just write down the numbers. I need to know if you have a firearm in your home, and whether it's a pistol, revolver, or some sort of long gun. We don't have to go into details. All right? So let me just see the paddles on row number 1 for that issue. All right, I have 2, 5, 9, 13, 18, 19, and 20. All right, so remember, it's not the details, it's just, do you have a pistol, revolver, or some sort of long firearm in your home? Number 2?
Yes,
And what is it? Not what is it, pistol, revolver, or long rifle?
pistol and long rifle.
All right. One of each or multiple?
Multiple pistols
Okay,
and one long rifle.
all right. Thank you. Number 5?
All three.
Number 9?
Yes.
All? Number 13?
All three.
Number 18?
All and probably my husband's agency issue stuff.
Okay. Number 19?
Pistol, rifle, shotgun.
Number 20? All 3 or? All 3. All right, very good. Row number 2, let me just see the paddles up high, please. On round number 2, we have 29 and 31. Okay, pistol, revolver, some sort of long gun. All, very good. 31?
All 3.
Very good. Row number 2. Let's see, show of paddles. Hang on a second. Didn't I say 3?
No, you said 2.
I apologize. Give me just a second. There we go. All right, row number 3. And see the paddles? I have 47, 59, and 60. All right, pistol, revolver, some sort of long gun. Number 47?
Well, my husband used to have a long gun that he inherited.
Okay.
He no longer has it.
Okay. Thank you. 59?
Pistol and long gun.
Number 60?
Well, my husband was in the Marine Corps for 30 years, so he has a lot of them. I don't know. I have a pistol.
Okay. And then husband, everything. Okay.
He was in the Marine Corps for 30 years, so not everything, but I don't know everything he has.
Very good. All right. Let's go to row number 4. Let me see, just paddles. Give me a moment. Hold them up high so I can write them down, please. Thank you very much. 65, 67, 68, 71, 75, and 86. Pistol, rifle, some sort of long gun. Number 65?
Yeah, pistol and long gun. 2 pistols.
All right. Number 67?
All 3.
All? 68? All? 71? 75? 86?
Pistol and rifle.
Very good. Row number 5. You can raise your paddles high so I can see, please. Thank you. We have 87, 93, 96, 101, and the glare on your cards hit me. I see 10. Very good. Thank you. All right, 87, same question. Pistol, revolver, long gun.
It's a handgun, but I don't know the difference.
Okay, handgun works. I got it. Number 93.
They're my husband's, but I believe it's both pistol and revolver.
Number 96.
4 pistols, 1 revolver, 3 long guns.
101 and 105.
Pistol and a long gun.
All right. Are we ready for number 6? Row number 6, I see 107. Yeah, it's the glare. That's all good. I appreciate you correcting me. 109. I'm sorry. Yes, 109, right?
All 3.
All right. The next questions deal with the items, the firearms that you've indicated you have in your home. Do you actually practice with them? So we're going to go row by row. As far as pistol, rifle, or a long gun, or revolver, row number 1, do you actually go out, let's say at least periodically, at least once a year, twice a year. I mean, we'll make it broad. You actually go out and practice. All right, let's see the paddles. We have 2, 5, 9, 13, 18, 19, and 20. All right, let's start with number 2. Where do you go to practice?
Shooting range.
A shooting range? All right. Any particular one?
The one in Suffolk County when I lived there.
Okay. Is it outdoor or indoor?
Oh, indoor, I'm sorry.
Indoor? While there, are you taking any specialized training or instructor from any of the individuals that are operating the range?
No.
When you go there, have you formulated a plan based on research, reading books, that you want to try to work on a particular thing? Or, and I'm going to use this very loosely, are you just slinging the lead downrange? You know what I mean? All right, so when you go there, what are you trying to accomplish?
Just the practice to better my shooting abilities.
Okay. Since you're training to get your license, have you had any formal training at all by anyone?
No.
Okay, thank you. Number 5?
Yes, sir.
Practice?
Yes, sir.
Where?
West Armory, they say rod gun, personal.
Yeah, I don't think you'll need a trainer. All right. Number 9, practice?
Yes.
You don't need a trainer either, right?
No.
All right. How often, number 5, how often do you think you'd go?
At least quarterly.
Quarterly?
Yeah, every 3-4 months.
All right. And number 2, how long do you think you'd go? Every 2 or 3 months, once a month?
Once every 6 months.
Okay, very good. Number 9, how frequent?
Once a month.
Okay. Number 13?
Yes, so, I moved here 4 years ago from New Hampshire. When I lived up there, we shot on private property regularly, so probably once a month. But since moving here, I think I've gone twice in the 4 years that I've lived here.
Okay. That'd be an indoor and outdoor range?
The one here in Dade City.
All right. Any formalized training by the individuals, they're volunteers there, right, that run the range?
I believe so.
Any individual training by any of those individuals? All right. Number 18?
Yes.
All right. How,
Once every other week or so we're shooting.
okay. Number 19?
I have not practiced since I've been in Florida, since 2016.
All right. And number 20?
Yes, indoor and outdoor, just for leisure and practice, targets, inanimate objects.
All right.
No professional trainer.
About how often?
It varies, twice a year, sometimes every other year.
All right. Very good. Row number 2, let's see if paddles. Who has a firearm that actually goes out and practice with it? All right, we have number 31. How often?
Since I moved here, we haven't gone. The pandemic started pretty much right after we moved.
Okay.
Before that, Minnesota, I would say every month, and prior to deer season, et cetera, just to check the rifle out.
Yeah, we're going to get to hunting here in a minute. Okay. Anyone else on row number 2? All right, let's go to row number 3, please. Let me see your paddles, so actually have the firearms and actually take them out of the house and go to the range and practice. I see no show of hands on row number 3. All right. Row number 4. All right, row number 4, I have 65, 68, 71, and 86. You kind of know the questions. What? Oh, and 75. I apologize, sir. Number 65, how often you go out?
Once a year, maybe.
All right. Since receiving your license, any formalized training?
Just my neighbor has a class 3.
Okay,
He's also a police officer for St. Pete.
okay. All right. Number 68, you actually take your firearms out in practice?
Yes, sir. Once a month.
Once a month?
Not my house.
All right. Any formalized training in that practice where you have someone as a coach or a mentor?
No.
And that would be an indoor and outdoor range?
Outdoor.
All right. Number 71,
Outdoor, mostly skeet shoot, target shooting,
skeet?
skeet.
Now, there's a difference between skeet and sporting clay. Which one are you doing?
Sporting clay. We call it skeet sporting clay.
Okay, sporting clay?
Yes.
All right. Anything with the pistols or revolvers?
Whatever, yeah.
Yeah, okay. And you're involved in that?
Yes.
All right. Number 75. Once a year. Number 86.
Sporting clays 2 to 3 times a year, and then once or twice a year we go to shoot straight.
All right. Row number 5. Let me see the paddles, please. You actually take your firearms out and practice. Row number 5, then paddles all the way up. I have 93. Okay.
Just the husband does.
Husband does? Do you go? Oh. Home with kids. All right, well, let me ask you this. If that wasn't an issue, would you be going with him? You have? All right. And you shot his firearms? And you shot your own firearm? Ever shot a firearm? Okay. All right. Anyone else on row number 5? All right. And the last 206, 109? All right. And the firearms that are in your house, do you, you go out and practice with them?
Yes, sir. I've been probably 2 times within the past 2 years.
Okay.
Both sporting clays and indoor range as well.
All right. Very good. We're going to take this one row by row. We're going to talk about being a member of the NRA. And being a member of the NRA does offer a lot of training through their program. And I want to discuss very quickly with you, if you are a member, your extent of participation, and any type of training that you took advantage of based on your membership. So let's just start with row number 1 as far as NRA membership. Is there anyone that's a member of NRA in row number 1? I see no show. I see no paddles. Row number 2.
Is that include spouse?
Sure.
He's in that.
All right. So you're all right. So row number 2, I have 29 and 31. And 29, your spouse is a member?
Yes.
All right. To your knowledge, does he frequent the annual membership conference, or does he go to the auctions that occur locally for them?
No.
All right. To your knowledge, has he taken advantage of any of the specialized training through the NRA?
No.
All right. Just let me mention some of the things that might jog your memory. The NRA offers the NRA Basics, a pistol shooting course. That's what some of you took for the CCW. They offer a course, Refuse to be a Victim, and they offer the NRA Hunter class. Those are kind of the ones you can do online and readily available. So that's what I'm talking about. All right, so number 31, your membership?
Yes.
All right. And how long have you been a member?
I'd say probably 10 years.
All right. And do you participate in any of the annual conference or any of the local auctions they use as a fundraiser?
No.
All right. Have you taken part of any of the classes, rather like the ones I read, or anything else offered by the NRA?
Not by the NRA, no.
Okay. Well, let's go ahead and talk about that now. Have you had any classes relating to firearms as it relates to either proficiency, use of the firearm, liability associated with the use of a firearm, or any tactics use of the firearm?
The only other one I had was a gun safety course in Minnesota so that we could get our certificates to hunt out of state. My son could hunt, he was required when he was young.
Mm-hmm. That's like the NRA hunter education. A lot of states recognize that.
That's very similar, yes.
All right, very good. All right, thank you. Row number 3. Same question, the NRA membership. I see none. Row number 4. I see none. Row number 5. All right, I have 93 and 105. 93,
Husband is, and no, he hasn't taken any courses that I'm aware of.
all right, very good, thank you. 105,
And my husband as well, he doesn't participate in any classes or any programs.
all right, thank you. Row, see, that was number 5, right? All right, the last two, row number 6. All right, thank you. I touched briefly, and I asked several of the potential jurors on the panel about specialized training dealing with the use of the firearm, either when you got your application or since getting your application. Now I want to be very specific, and we're going to go row by row. Has anyone had any specialized training dealing with how to effectively and accurately fire a firearm, dealing with the criminal and civil liabilities associated with the use of a firearm as a civilian, or training with respect to defense use of a firearm, not grappling or anything like, just use of the firearm? All right, everyone got the question, kinda? I'll repeat it if necessary, but anyone on row number 118?
Like the legal training you're meaning, like what I understand as a former prosecutor, like what I instruct people?
No, I'm looking for when did you go out and were you a student? Not were you an instructor, but were you a student where you received training regarding how to effectively handle, shoot a firearm, the liability associated with the use of a firearm criminally or civilly, and anything with respect to how to use the firearm in self-defense? Someone that's an instructor where you went to a class and not some online YouTube video, okay? No. All right, number 9? All right, so let's do that. Let's start with row number 1, and we have 9, the formal training in those aspects. You've had some formal training?
Yes,
All right. When did that training start?
4 years ago.
Could you speak up just a little bit for me?
4 years ago,
All right. Has it been ongoing since then?
once a month.
Okay. Has that training included the criminal and civil responsibilities and liabilities that can be associated with gun ownership?
Yes.
Okay. Who taught that part? Who was your, not name, but give me a background of the individual who taught that part.
It was Orlando State Trooper, Police Department officer, and a Navy SEAL.
All right. All right, thank you. Anyone else on row number 1? All right, let's go to row number 2, please. Same question, formalized training. I see no show of hands. Row number 3? No show of hands. Row number 4? Number 68? Other than the military, anything as a civilian?
Just the military.
Just the military. Let me talk about that just for a minute. In the military, you have what's called rules of engagement that apply. Right. If you learn through this case and through the instructions by Your Honor that the laws of state of Florida, I need a drink of water. The rules in the state of Florida are different than the military rules of engagement. Can you set that military experience aside and follow her Honor's instructions to you?
Yes, sir.
Okay. All right, let's go to, see, that was row 4, right? So row 5, any formalized training? I see 96. Anyone else in 5? Okay, 96. What formalized training, formal training have you received?
New York State Department of Corrections.
The Department of Corrections. Yeah, we talked about that. Anything else? All right, very good. All right. We're going to do this row by row. This is going pretty good. We're moving along. Let's go row by row with the next issue. We have that some of you have applied and received your CW, that you actually have a firearm available to you if you want to carry, and those of you that want to practice, we've talked about that. Now the next part. Has anyone had to defend themselves with a firearm? And I'm going to exclude military environment, civilian. As a civilian, has anyone had to defend themselves using your firearm? Anyone on row number 1? I see no paddles. Row number 2. No paddles. Row number 3. No paddles. Row number 4. No paddles. Row number 5. 96.
This wasn't in the course of my job, but in New York City, I was also a local fire chief, and I did have a carry concealed permit for the state of New York, and my law enforcement badge. I carried weapons under. We responded to a possible suicide one night, and I was the first to arrive on scene, and out behind the garage walked a gentleman with a rifle in his hand. So I took cover and drew my weapon and had to do it if I had to do it.
Okay. What year was that, sir?
I want to say around 2015, 2016. It was sort of third again before I retired.
Right before you retired? Here, approach, John.
Yes.
Number 96, would you come up to the bench, please? we're still going to talk kind of row by row. We've gone through several aspects of firearm usage. There's another aspect of it that a lot of people engage in, and that's hunting. Whether it be by pistol or lawn gun or black powder, bow and arrow. So let's talk a little bit about that. We're going to go row by row, and I'll write down the numbers. It seems to be working. We get through this pretty good. So row number 1, do I have anyone who participates seasonally in hunting, whether it be rifle, black powder, bow? I think that's the 3 that I'm aware of. Crossbow. That's right, this crossbow. So bow, crossbow, and black powder, and rifle. All right, so row number 1, that would be 5 and 9. All right, sir. What season do you hunt?
Deer and duck.
Do you get out early for the black powder?
No, sir, I don't get black powder.
All right, so strictly rifle and shotgun? When you hunt the deer, stalking, blind, tree stand, give me how you do it.
Blind and tree stand.
Have you been doing that locally here, or do you go to another state?
Not locally, it's North Florida, Georgia.
Okay. Okay. Thank you. Number 9?
Deer and moose and hogs.
Moose?
Moose and hogs.
Oh, feral hogs in Texas?
Yeah.
Yeah, okay, yeah, I gotcha.
Watch them here.
There, yeah, I know, yeah, I gotcha. I only saw this show on Texas, so I'm sorry. But I was familiar with it. All right, deer and hogs. All right. Same question I did number 5 as far as the deer. There's several ways to do it. Stalk, blind, tree stand.
Tree stand.
All right. Anyone else on row number 1? All right, row number 2. Hunters seasonally go out. Number 31. When do you go?
Deer, ducks, and grouse.
Okay. Now, number 9, let me just quickly go back to you because I made the assumption, maybe incorrectly, that it was strictly a long rifle. Any crossbow, bow and arrow for the deer?
Compound bow or long rifle.
Compound, okay. And let me just quickly follow up with number 5. Any crossbow, bow? Okay, very good. Now I'll know to ask everyone. All right, number 13. Deer, ducks, and grouse. All right?
31.
All righty. With the deer, stalk, blind, tree stand.
Blinder stand.
All right. And do you take part in any of the specialized seasons where you can hunt with a crossbow or black powder?
No, revolver, long rifle, shotgun.
Very good. Anyone else on row number 2? All right, row number 3. I see no paddles. Row number 4. Number 86. What season are you participating in hunting?
Turkey.
All right. That would be shotgun?
Yes, sir.
Now, with the turkeys, is it mostly stalking and blind?
Yes,
You ever use a tree stand?
no, sir.
Okay. Thank you. All right, row number, I think I'm up to 5, right? Row number 5, hunters that go out during the season, and row number 6. All right, thank you. I want to get back now to talking a little bit about the process that you're going to be involved in. We've gone through several stages of it. One of the things that we previously talked about that's not appropriate in the jury room is thinking about the sentencing. We've discussed that. There's also another aspect that's not appropriate, and that is sympathy. Just as important that you not think or talk about sentencing, sympathy for any of the parties involved is not a factor in your deliberations. How you individually feel about one individual or another as it relates to sympathy has to be kind of bottled up, not shared, and you strictly relying on the facts, testimony, physical evidence that is provided to you, instructions given to you by the court in your deliberations. Just as I did when we talked about sentencing, let me ask a couple of you. Number 40, where are you? There we are. We talked about how important it was not to have the sentence percolate into your discussions. How important it is to you not to have sympathy percolating, if you will, into your discussions? How important is that to you? Okay. When we talked about sentencing, one of your panel members said it was paramount. Y'all remember that? Do you agree or disagree with me that it is paramount that sympathy does not become a factor in your deliberations? Loud? Yes. Very good. It frequently occurs during a criminal trial that people with specialized knowledge are called by either of the parties in order to provide you testimony that you may consider during your deliberations. They might be referred to as an expert witness. This is someone that has some sort of expertise, that has some sort of specialized knowledge, that is allowed to testify not only in the form of a witness, but also to give an opinion. What you will learn is that that person is an expert to the extent that you judge them to be. Okay? You'll be told that you can either accept or reject all or part of an expert's testimony, just like you can any other testimony. Let me just pick on number 18. You're familiar with that concept?
Yes.
All right. And that particular concept, would you agree or disagree that is consistent with the role of a juror as far as you are the one who determines credibility and who you believe?
Absolutely, yes.
And that applies to an expert witness or a lay witness?
Yes.
All right. Let me just ask as a group, let me just go quickly row by row. Is there anyone who will automatically accept, without any further discussion or analysis, the testimony of someone who has been called an expert witness? Anyone will just automatically accept it and not do any thinking more about it? Anyone on the first row? Anyone on the second row? Anyone on the third? Fourth? Fifth? Sixth? All of you agreed that you can weigh and judge the credibility of every single witness that comes into this courtroom, regardless whether they're a lay witness or an expert witness. Let me see a show of hands of everyone that can do that. Thank you. All hands up. I've been a prosecutor long enough to have gone through some changes in the way we do things in the courtroom. When I started, certain things occurred, and that's changed. Our society has changed. The rules have changed. The jury now, with the discretion of the court and some guidance by the rules that we have, can participate in some limited way. And one way that a juror now can have a little more participation, if you will, is note-taking. When I first started, you didn't have that option, but now we do. And I need to speak with you about note-taking because as adults, well, give me a hand. Who's a teacher? Don't we? Number 86. Are you familiar with the adult learning theorem? All right. People learn different ways. We're either visually, auditorily, or hands-on. Right? Okay. And that's what I want to talk about. See, when you start taking, if you're a note taker, then you're listening and taking down notes as fast as you can, maybe. Or you're a note taker that just does highlights. Some people won't take notes because they just want to listen. That's too distracting. See where I'm coming from? So I need to talk to you a little bit about you as a note taker, and kind of give me a feel of how you're going to, if you want to, accomplish that. So let me just start on the first row. Who is I'll just call it a note taker. Who's a note taker on the first row? Number 18. All right. Okay. I'm going to ask her some questions. Everyone, please listen, and it'll go a little bit quicker then, because I'm going to follow up with you, okay? You don't mind me picking on you just a little bit? Okay, let's talk about taking the notes. You're a note taker?
Yes.
All right. The notes that you take, are they as detailed as possibly you can, or is it a topic, or just a word? See where I'm going on the spectrum?
Between the most detailed and the middle.
Okay.
So if I were to drop dead, someone could make do with what I'm writing.
Okay. All right. You go back into the jury room and say there's 3 or 4 other note takers. And you're all looking at your notes and you're having your conversation. And then you have one of the jurors say, I don't have that in my notes. And you say, well, I have it in my notes. You see where it can go?
Yes.
As some people will gravitate to a different aspect of what they put down on paper. Okay? How would you handle that situation? You're back there with those 6 people. You now have notes that just doesn't have this. It's not in conflict. It's just one has it and one doesn't. What are you going to do?
I guess I would go with what my recollection is. Like, I would also probably have a personal recollection if I wrote it down. So I would go with what I can recall. And I don't think I'm going to impose my will on somebody else either, though. So
Did everyone hear her response? Say yes or no?
Yes.
All right, everyone hear the response? She would go with her recollection and her notes and let that be her guide. All right, let me ask as a row number 1, do you agree or disagree with the analysis of juror number 18? As if there's an issue with note-taking, you rely on your personal recollection, your notes, and making your deliberation. Do you agree or disagree? Let me see your hands that you disagree. I see no show of hands. And let's just, since everyone heard it, row number 2. Show of hands that you disagree with the analysis that juror 18 just explained about note-taking. Anyone disagree? Juror number, let me get my chart, or hold up your paddle for me. All right, juror number 26. Tell me what your thoughts are on that.
Well, maybe she missed something in the testimony.
As far as her notes?
Yeah.
All right.
Perhaps she was writing something down and then some other detail that was said she missed while she was note-taking, but then someone else picked up on that detail.
Okay. And then she indicated, well, then she would rely on her recollection. So let me ask you the same question. If you were in that situation, how would you handle it?
Did any other jurors pick up on that detail that I may have missed?
You'd make a little more inquiry?
Yeah.
Okay. Would you rely on your own recollection as the final analysis?
If there were several other jurors picked up on that detail that I missed, then I would vote the majority.
Okay. In the event that, in that situation, you had 3 note takers with 3 different answers to whatever was being resolved, all in conflict, and all you were stuck with were your own recollection, how would you resolve that?
I don't have to say about recollection.
Okay. Would you agree with me that at some point you have to circle back to your own recollection?
Yeah.
All right. In the event that the note takers are adamant that their notes are correct and your recollection is wrong, how are you going to handle that situation? It could happen, right?
Yeah, it can happen.
Yeah, so I'm just trying to, there's no right or wrong answer. It's just now you're confronted with 3 note takers saying if this is the way it occurred, and it's different from your personal recollection. How do you resolve that?
But do those 3 note takers agree with each other?
They all agree with each other, but your personal recollection is different than those 3 note takers. Where are you going to go?
Well, in that particular situation, then I'm going to assume that I missed something. But if the other 3 note takers all have different opinions, then I'm going to rely on what I know.
If it was the same topic that you didn't miss, but the 3 note takers had one answer and your, I'll call it an answer, was different on the same topic, how would you resolve that?
Well, then we're going to have to talk it out and see if we can come to a consensus.
Okay. I guess the point I'm trying to make, would you automatically yield to the note takers if their collective recollection is different than your perception? Would you automatically yield?
No.
Okay. Did everyone hear his response as far as handling the situations and how you're going to rely on note takers within the jury room? All right, so, and I appreciate you bringing that to our attention, so let's discuss that a little bit with row number 2. In the event that you have a situation where the note takers are collectively against you on a particular topic, and on the same topic you have a recollection, is anyone going to automatically yield to the note takers? Anyone on row number 2? Number 15, let me ask you, would you do that? Would you automatically yield?
No, sir.
All right. Would you at least try to discuss it and to see, to come to some consensus?
I mean, I would listen to what they have to say, but ultimately it's what I believe, what the evidence was presented, that's what I would go by.
Okay.
I'm ultimately responsible
but you would be open-minded in the
Yes.
jury room to
Correct.
hear everyone else's.
Correct. That's
Okay.
ultimately my decision, my recommendation.
All right. Anyone, I'll, in just a minute, anyone, would you, on row number 2, would you automatically yield to the note taker if it's different from your recollection? Let me see a show of hands that would automatically yield. Number 42, you have a thought on that issue.
Yeah, I think that if it were some kind of evidence that could be retrieved, like if I could ask the judge to show us.
See a picture.
Yeah,
Was there a cat next to the dog and no one can agree?
right.
Okay.
But there was a picture.
Okay.
And then if I could ask the judge to have us see the picture and maybe come to a resolution that way.
If it was just testimony, everyone's writing down their notes, testimony from witnesses, doctors, experts. There's no physical evidence that you can rely on. It's simply your recollection. Are you going to yield to the 3 note takers to say this is the way it was, or are you going to rely on your own recollection?
I'm going to go on my own recollection.
Okay. Row number 3, let me see a show of hand. Is there anyone that's going to automatically yield to the 3 note takers that have information written down that's different than your own recollection? Let me see a show of hands. I see no show of hands. Row number 4, is anyone going to automatically yield to those 3 note takers? I see no show of hands. Row number 5, same question, no show of hands. And row number 6. Yes, sir. Let me, do that for you. Number 27?
I have a question in relationship to that. If we were in the jury room and we were deliberating, and something was a question that, do we have a right to review the court reporter's notes?
There are procedures that are set up, so I won't go into detail. That would be more appropriate for the court to do. But I will tell you that you can ask that kind of questions to the bailiff, who will then present it to the court, and then the court will discuss it with the attorneys. And then, so I can't answer the question, but procedurally, there's an avenue for you to have that answer.
So if we had a conflict of, say,
No.
half and half, and we had conflict in data.
No, I will tell you absolutely, we cannot participate in your deliberation. That's why we're talking about this, as
That's what I wanted to ask. This is
yeah.
knowledge, to know what.
No, you can't.
Mr. Martin?
Yes.
Hello. I can kind of answer that as a matter of course. Typically, no, you will definitely not get a transcript back. And I prefer that you do not get a read back. So there'll have to be a really good reason given to me why you have to have a read back. So it's important that you hear all the testimony at the time it's given, and because chances are good you will not get another chance.
I just wanted to know.
That's why I don't answer that question. All right. So let's get back to that issue, because you can see it's kind of important. We kind of need to know what your personality is, so that we're trying to figure out what 6 people, their own traits, training, personalities, will be a good fit for this trial that can work together collectively within the jury room. That's the reason for all the questions. There's no right or wrong answer, but we're just kind of get a feel for how you handle certain things based on your own personality. So, in dealing with the note taking, I think we've kind of drove the point home that if you are taking notes, it's great. You can rely on to refresh your memory. It's great if someone else has a note that maybe you didn't have collectively. You can either agree or disagree with it, but will everyone agree with me that as a note taker, you will not automatically yield to the information in someone else's notes? Everyone agree? Yes. All right, very good, thank you. I'm going to get away a little bit from you and talk about this side of the bar. In a trial, the attorneys from both sides, to facilitate the presentation of evidence that you can hear, at times will have to, out of your hearing, have a conversation with the court. Because we want to make sure that the information that you receive is proper, lawful. Sometimes there's some gray areas, but it's the court, Her Honor, that ultimately decides, and we seek out her guidance. She'll give it to us, and then you'll hear the information that's allowed. But you're not going to be able to hear what we're talking about. There may be some type of testimony going on about A, B, and C, and then there's a question about D. Oh, objection. Oh, wait a minute. We know the question is D. I wonder what's going to be said. And all of a sudden, here's this confab up at the bench, and all you see is this part. All right? And you're going, I'd really like to know what D is. And we all come back. I get back to the podium, and I move on. The witness doesn't get to answer D. All right, so that could be kind of annoying, right? You're anxious, what's D all about? You're not going to hear it. So let me ask you this. Where's 109? Thought I'd never ask you, right? Because you're the last one way back there. Would you do me a favor, sir? If you don't mind, just stand up so I can hear you. I'm going to use you. We're up here at the bench, and you don't get to hear the answer to 109, but you would really like to hear it. All right. And then we move on. How do you feel about being left out of that conversation and not hearing the answer to D? What would be your thought process if you sit there?
Your business is your business.
All right. Are you going to attempt to speculate or guess what the answer might be?
No.
All right. How would you handle that in the jury room when someone said, well, we didn't hear D, and everyone goes, yeah, I'd really like to hear D. And then there's a lot of talk about, well, what maybe it could be. How are you going to handle that?
I think that's about all that it would be, I guess.
Yeah, you just got to ignore it, right?
Yeah.
You can't speculate what the answer to D would be, right?
Right.
All right. Does everyone on the first row, thank you, 109, does everyone on the first row agree that in your deliberations, you can't even think about, speculate what you are not allowed to hear? Even though you're curious, it just can't come into your deliberations. Everyone agree they can do that on row number 1? Let me see a show of hands, row 1. How about show of hands, row 2? Same? You agree that you can just forget that? Row number 4, every show of hands, everyone agree they can just not speculate about that? Row number 5, again, you're not going to speculate about what the answer might have been, right? And row number 6, all in agreement. I discussed that with the jurors because it would be contrary to the instructions by the court. And you've heard Her Honor say numerous times, you can only consider the evidence that you hear in the courtroom. So by speculation, what D answered, you didn't hear it. If you did try to speculate and factor it in, you would be, I'm going to pick on number 18 again, because I know if you did speculate, would you be following the law or not following the law?
Not following the law.
And does everyone agree it's paramount that you follow the law?
Yes.
All right. I once regretted asking this during voir dire. and for some reason, I still ask the question. But I can't think of everything. You've been through the process for a couple of days. You've heard our questions. You know the process that we're trying to go through. We're trying to get a group of individuals that will be compatible enough to work in a close quarter, discuss the case, and to be able to voice their own opinions and to engage in the discussion, and then collectively reach a verdict, right? That's what we've been talking about. Everyone understand the process that you're going to go through? Yes. All right. But I can't think of everything, and as you sit there, I'm going to ask you as a group, is there anything, now that you know what the lawyers are looking for, that you feel the lawyers should know as to whether or not you would be unable to perform the duty as a juror? Is there anything out there I didn't talk about or didn't ask about that you were going, yeah, now I know the process, this ain't for me? Is there anyone, this is the whole group, let me see a show of hands that has that thought right now. I see no show of hands, thank you. And I know I've covered this, but I'm going to collectively put it together in one sentence. We're going to do it as a group. Because we've talked and we've used the word paramount. Remember, we used the paramount term when we talked about how important it is as far as not to be considered sympathy and sentence, right? Can everyone agree now and understand how paramount it is that you follow the law, that you make your decision in this case based solely only on the evidence, the testimony, coupled with the law given by your honor, that is only thing that is considered to determine guilt or innocent, and that the thoughts of sentence and sympathy will be totally left out of your deliberations. Can everyone agree to do that? Yes. Yes? Everyone yes? Yes. All right. We talked about guidance and how you perform your job. We're going to give you, Her Honor will give you numerous instructions as guidance that you've all agreed to follow so that whatever verdict that is returned, the community can have confidence in. And that's the most important thing, right? One thing that you can use, you can bring with you, Her Honor will say that you can use it, is your good old common sense. I know there's a lot of legal terms thrown out at you. There's a lot of guidance given to you, but that doesn't preclude you from using your good old common sense. So I'm going to ask you, can everyone, if you're selected, bring that common sense with you and use it liberally as part of your guidance in this case, so that whatever verdict is returned, the community will have confidence in that verdict. Everyone willing to use their just good old common sense in deciding this case? Yes. Thank you, folks.
Thank you, Mr. Martin. Perfect time for a lunch break. We're a few minutes before noon. Who's going to do the questioning for defense? Excellent, all right. So Mr. Michaels will begin after lunch with his questioning, and then we'll go through that process. All of you remember my instructions during the recess. Don't do any independent research of any sort. Don't talk about the facts of the case amongst yourselves or with anyone else. Please keep your badges on at all times when you're not in your personal vehicle. Even then, I don't know why you would want to take them off. They're pretty cool looking. So, anyways, we'll see you back. Let's come back at 1 o'clock. I think that'll be a good lunchtime, and we can get started and get going. All right. Thank you, everybody. No, we've only got one. That's right, and we're going to let him go. I think we did drop 96, so he won't be coming back. But that was the only one. So, to get started, you want to line them up? Yes.
Prospective jurors enter the courtroom.
Thank you. Ladies and gentlemen, welcome back. Were you all able to be, counsel, you can be seated. Were you all able to abide by my instructions during the recess? Yes. Excellent. All right. You guys are getting to be well-trained. You all speak loudly, and I'm sure you're lining yourselves up pretty well. That's, I tell you, enough repetition, and we can all get it. We're ready to begin with Mr. Michaels. Excellent.
One brief thing I forgot to broach with the court, and I approached with the state. Your Honor, I'm sorry.
It's all right.
Mr. Escobar reminded me.
It's not.
On the record.
Are you good?
I have a very small area here, and there's a lot of you, and so I have a lot of papers. So I may be walking back and forth to the desk over there while I'm talking to you. My name is Dino Michaels again, and myself, Richard Escobar, Matthew Funderburk, and Karina Flores represent Curtis Reeves in this matter. What I do before I speak to a prospective jury pool like this, the night before I try to think of something to say, because I know sometimes it gets kind of boring, just hearing the same questions over and over again, not just from the prosecutor, but from anybody. I mean, this kind of selection process is difficult, so I always try to think of something to come out and really catch your attention. And I really didn't come up with anything. This morning, early, I woke up, and it occurred to me, and I kicked myself because I'd never said this to a prospective jury pool before. And by the way, I know you heard this is called voir dire, French for speak the truth. Really, I think the English version describes what it is. It's jury selection. We're trying to select a jury. So in that vein, my thought is this morning it pops into my head, we're living the Constitution. And say we're living the Constitution. Because we are. We're living the Constitution today. We talked about, well, first of all, we talked. That's the First Amendment, the Bill of Rights, right? It was ratified a couple years after the Constitution itself, frankly, because the framers and the signers thought that it was embodied in the colonies already. So we covered the First Amendment because we're talking, and you can speak freely. We talked a lot about the Second Amendment. The first row, except for number 15, all have concealed carry, or had at some point, and so we've talked about the Second Amendment. Let's talk about the Fifth and Sixth Amendment. The Fifth and Sixth Amendment guarantee an accused individual the right to a fair and impartial jury and a fair and impartial trial, which is interesting. We use the term fair and impartial because really, if you look at it, the Fifth says impartial and the Sixth says fair. And so, at any rate, we're going to be an impartial and fair. All right. And the interesting thing is we have somebody called the defendant. I'd like to talk to you all about that a little later. It occurred to me here it's State of Florida versus the defendant, Curtis Reeves. But when you look in the Bill of Rights, it doesn't talk about a defendant. The Fifth Amendment talks about a person. The Sixth Amendment talks about an accused. So really we have a citizen accused here, and we'll get your ideas on that. The other thing that I was thinking about is really what I'd like to do is to get your help, to help me understand what your thoughts are, your thought processes, your opinions, and your experiences in life to help me understand how you make decisions and what you think about these different ideas in our law. So let's talk about a couple follow-up questions, some follow-up questions on the state's jury selection questions. And some of the follow-up questions are going to be to just get some amplification on your answers, why you answer a certain way, why you do something. So I'm going to go through those first. I made some green marks to remind me. All right, number 20. There you are. All right, number 20. I know you answered a question involving a time when you were in St. Pete with some friends, you were young. Tell me a little more about that. How did that happen?
Just, like I said, I was about 20, I was about 20, 21 maybe. Some friends said they were gonna go out to St. Pete. I really only knew a handful of them. So we went in my vehicle. We were out there, met up with some other people they knew. And there, at the time, were tons of just crowds of young people going out that way to party, basically. And so
And so that was your truck, right? Because I think you said it got pulverized.
Yeah,
And so, let me talk a little bit about that experience. You were how old then?
roughly 20.
Okay. When you're 20, what kind of decisions do you make in terms of, hey, let's go to this place you've never been with some people you don't know, and let's meet up with other people you don't know. Tell me why you did that when you were 20 years old.
I hadn't had any life experiences to lead me to believe that there was anything wrong with going out and about. Ybor used to be real popular for people at that age. The same kind of stuff goes on in Ybor, but you're not in your vehicle typically, you're walking. You're lucky in a vehicle, doors locked, but I haven't had any reason to think that wasn't a great idea. Now looking back, I think, I can't believe I considered those types of situations entertainment,
Right. Seeking entertainment and getting entertainment, but not the entertainment that you were seeking.
It didn't go the way I thought it would.
Right. It was exhilarating, but not fun.
Yeah, it's a good way to say it.
Now, let me ask you, how old are you now?
43.
All right. A 43-year-old Mr. 20s. Buddy calls you on the phone and says, hey, remember that time we were in St. Pete? We had a blast. Let's go with some people I don't know and you don't know. We're going to meet some people that we don't know. Would you do that now at 40?
Hell no.
And why is that?
I have since learned to be more selective of the company I keep, and I consider just past experiences to kind of dictate where I'd want to go. I steer clear of large crowds or potentially rowdy or drunk people if I can. And, I don't know, it just doesn't sound like a good time anymore.
Now, tell me this. When you got to wherever you were going, did everything look all right at first?
At first, yeah.
And all of a sudden, it was not all right. Is that fair to say?
It was like a light switch went on.
Was it something that you expected? Was it something that you were looking for? And so did that teach you anything about being in unfamiliar surroundings?
Yes.
Okay. Number 13. Oh, there you are. Number 13, you talked about a family member who had charges dropped. It was your husband.
Yes.
And you told me, I think, the question, I mean, it was in that section where, having contact with law enforcement, something like that. And then I guess the question was something like, well, would you hold it against law enforcement or something like that? And you said you were angry at your husband than law enforcement.
Yes.
Okay. So tell me what you know about that particular case. The charges were dropped, right?
They were.
Okay.
So we were at our community pool in our neighborhood for a going away party for one of my son's friends. And the adults, some of them were drinking, and there was a group of young gentlemen who were kind of playing football around the pool. The clubhouse manager had come out a few times to tell them to stop, and they just ignored her. She was clearly frustrated. They ended up throwing the football, and it hit my vehicle over the fence. So my husband asked them, hey, the toll, cut it out. They didn't listen. They were just out of control. They were disrupting everybody's time in the pool. My husband started yelling at them again. One of them ran up and got in his face, and they had an altercation, and the man threatened my husband, and my husband shoved him one time. And he ended up getting arrested for that, because we found out later that that gentleman was actually 17. I thought he was at least low 20s, maybe a college student. He was physically larger than my husband.
All right.
We didn't know he was 17, and that's why he was arrested, but the law enforcement did review the tape from the pool, because everything is recorded out there, and it's my understanding that, the prosecutor wasn't looking to pursue anything, and it was all just wrong.
Okay, so it started out as really kind of a request not to do something that you shouldn't be doing. Is that fair to say?
Yes.
And then it escalated beyond what your husband expected. I'm not trying to put words in your mouth. Is that what you're, do I understand you? Okay. And because of the kid's age, your husband gets arrested?
Correct.
Okay. There were a lot of questions, so I have a lot of pages. I'm going through it. Mr. Martin did a thorough job. Let me see what I have here. All right. I think there was one of these group questions that said, do you harbor any ill will against the prosecutor's office? And everybody said, no, I wouldn't. Tell me, number five, Mr. Number 5. As an attorney, the other thing I'll tell you, the most difficult thing to do is to call you by your numbers, because I'm so used to doing this or anything else and calling people by their names, that even though I try to prevent that from happening by scribbling out on my chart your names, I still look through the scribble to find the names. It's just, so I didn't say it, so I'll say number 5, Mr. Number 5. Tell me why you said that. Oh, I'm looking at the wrong place. You're number 5. Mr. 9 is number 9 next to you. Number 5. So let me ask you that. What did you mean by that? You wouldn't hold any ill will. What did you take that question to mean?
I mean, you take it as you're not going to hold any ill will towards the state, towards the defendant, anything. You're here to do a job, and you're here to do it equally and fair.
Okay. And so you beat me to my question, because my question was, if you didn't hold any ill will to the prosecutor, do you also feel the same way about the defense? Number 46. There you are. What do you think of that idea?
I believe the court has its rules, and they're going to provide us the information. We take that testimony based on facts and determine if there's reasonable doubt.
Let me tell you where I'm coming from. I'm a defense attorney. From the very beginning of my career, all I wanted to do was to defend the accused people. That's all I wanted to do. Never wanted to be a prosecutor. This is all I wanted to do. And so I get the question at parties when I'm there with my wife, how can you do that? Right? How can you do that? You must know some of the people you represent aren't innocent. How can you do that? So do you think that there's something wrong? You know, are you going to hold it against defense attorneys? No, you're shaking your head?
I'm sorry.
It's all right. Number 65?
That's me.
I know. What do you think? This time I was looking at the right place. What do you think of that idea? Like the prosecutors, because, I mean, you told me that, or told the prosecutor, a lot of your friends are law enforcement, right?
Yeah, we have a lot of law enforcement, yeah.
And so tell me how that sits with you.
Well, again, I mean, I was a former sports agent, so my, partners were a prosecutor and a defense attorney going to the NFL draft and having those conversations between the two. I think each side has the right to prevent it, and it's going to be up to the jury to look at all the facts, whatever the facts may be, and be non-biased.
And I know you mentioned that the fellow you worked with, the attorney, was defense attorney locally?
Oh, yeah, Kaminsky.
Okay,
Pasco County.
right, okay. The other thing, I didn't get to it yet, but since I'm with you, I'll talk to you about that. You talked about, I think it was something about grappling or
Boxing.
boxing. I know that you said a sparring partner.
Yeah, sparring partner.
That's what I wanted to ask you.
Yes.
When you say sparring, tell me what you're doing. Actually,
Yeah, we actually spar, train, cardio, but also self-defense, but really improving ourselves, physically, but also mentally, boxing-wise as well.
okay, so boxing,
Yes.
good old-fashioned boxing,
Yep.
the sweet science,
The sweet science.
not using your legs,
Not kicking.
not choking anyone.
Not choking, just, complete boxing.
All right. Let me talk to you a little bit about that. Can you hurt somebody by punching them?
You can, absolutely.
And so what kind of injuries have you seen that a punch has done?
Well, personally seen, just knockouts in the gym, so on.
Just knockouts, you say, very nonchalantly. Okay. I mean, certainly you've seen, I mean, I used to watch boxing. I can date myself, you know, I think, I do remember watching Ali and Frazier, and I did watch Thomas Hearns and all that, but I see cuts on the eye. Can that happen?
You got cuts on the eye, nose, you can miss a teeth or a tooth.
Right,
You can be missing, depending on how hard the punch is.
right.
Jaw, you can have ribs, chest injuries.
And if you're Holyfield and you fight the wrong guy, you can have part of your ear missing.
You can have the ear,
And let me ask you this. When you box, they're different, I mean, you wear gloves.
Yes.
Padded gloves, and your hands are wrapped.
Yeah, and headgear.
And headgear. You wear headgear.
Yes.
The pros don't wear headgear.
Right, well, they're actually in the ring under a sanctioned bout, but yes, otherwise sparring, yes, they wear gear.
Okay, but you can still get hurt wearing headgear.
Yes.
Tell me why it is that boxers wear gloves.
Well, they have the different types of, you know, you have your regular padding, you have horse hair inside the gloves. Sanctioned 8-ounce gloves for professionals. It's, you know, it's what the state record, you know, the state commission for boxing says 8 ounce for professional fighters. They have to meet a certain criteria. They all have to be the exact same. Unwrapped, they go through their inspections, cutting the gloves to see if they're been tampered with. Make sure the padding is correct, so it doesn't give one side more of a fair opportunity versus the other side.
Okay.
They want it to be equal.
Now, I love that movie Fight Club, all right? They don't wear gloves in that movie, right?
Right. Talking about bare knuckle fighting.
Yes, bare knuckle fighting.
Yes.
Why don't they do that?
Well, there is a professional sport for that now.
And what, is that more dangerous?
I would say it's a little bit more likely to get a concussion or two.
Well, what about cuts?
Sure, it's more of a gruesome, you know, sport, just like UFC, you know, where you have grappling and everything else, so yes.
Right, bare knuckles, right?
Knuckles,
They're like little pointy bone protrusions out of your hand,
yes, sir.
and they look like they can hurt.
They do hurt.
Okay, so you've been hit with a bare knuckle?
I mean, of course.
Okay. I mean, as I was asking you that, I'm trying to think back if I ever have, and I have. I'm not going to tell you the story, but nonetheless, did it hurt?
I think it probably felt pretty good, in a sense of, yeah, well, it wasn't very pleasurable, but did it hurt to the point of being knocked out? No, but, you know, did it hurt? Yeah, it hurt.
But it also could have caused some serious injury, right?
It should have.
And I know I've seen some of the YouTube stuff. I don't know if that guy's still around. Do you remember Kimbo Slice?
Yeah, it was nice, yes.
Okay.
Before you died.
Right. And so he was a big backyard bare knuckler. And some of those people got pummeled.
They got hurt.
Now, Mr. Number 9. I was looking at you, calling you 5. You were shaking your head yes when I was talking about, you know, can a hand, a bare knuckle do serious injury?
Yes.
Tell me what you know about that.
I've been punched with them. I've seen eyes pop out, it's like a dislocation of the eye. I've seen, obviously, bloody noses, bloody lips, broken jaws, missing teeth. I mean, compared to boxing, mixed martial arts, you're not just using your hands, you're also using feet and everything else, but being punched by a bare knuckle, I mean, it can be considered a lethal weapon sometimes.
All right. And in your training that you talked about, are you taught that the bare hand can be a deadly weapon?
If trained, definitely could cause that.
Let me ask you this. Do you have training that tells you you can look at somebody and tell if they have the training to have this hand be a deadly weapon? Can you look at me and tell me if I have?
No.
Okay. Can you look at anybody and tell if they have?
No.
All right. And I always think of Bruce Lee wearing like a loose like wearing a loose sweater and some sweatpants, you know what I mean? You look at Bruce Lee and you say, this guy, I'm gonna kill this guy, right? Okay. What about, see. Number 63.
Yes.
There you are. What do you think of that idea? You know, you were part of the group that said, yes, you know, I have no ill will towards a prosecutor. You know, now that I said it a couple times, ill will actually, that's like having a bad feel. What does ill will mean to you?
That you don't have any animosity
That you don't have.
against anyone.
Okay. So animosity would be like an emotion,
You're right.
and is that like hate or like love?
Right.
I mean, you got to put an effort into having that emotion. Is that right?
Correct.
And so take the emotion part out of it.
Right.
As a human being, let's talk about this fair and impartial, or as the Bill of Rights tells us, impartial and fair thing. You know, we say that as lawyers, we forget what we're saying half the time. We speak in this lawyer speak like voir dire, fair and impartial. We say these things, and really when I think about it, sometimes I'm driving home and I say, you know, what the heck did I just say? Do I even know? We're so used to saying it. And so I think that what we lose sight of as human beings, in order to be fair and impartial in this arena of living the Constitution, we have to maybe put it into a human context. And so my best way to illustrate it is I would say a story, but it's not a story. It happened to me regarding my wife. She worked for hospice. She did house care, you know, health care in the house. She's a nurse. Did it for many years. Always been in houses. Some of the people who needed help lived in terrible, really dangerous neighborhoods, not great conditions. But she went. She was a little soldier. She still is. And I also tell you that so you know I'm married to an angel. But that's just me. And so she'd been doing this all this time. She came home and she said, honey, today I got bitten by a dog. So I'm thinking, well, I know you've been around pit bulls. No offense to anybody who has a pit bull. I had one for a little while. You've been around whatever dogs, goodness only knows. It was a dachshund. A dachshund. A dachshund is on the way out, jumped up and bit her right here in the hamstring. You know, it didn't break the skin. It shook her up a little bit, but like I said, we've always had dogs. So she's a trooper. She went on. Within a week, I think it was 4 or 5 days later, I don't remember exactly now, she's in another house. You guessed it, a dachshund. Even worse, to add salt to the injury, to the wound, this dachshund was paralyzed in the back legs. And somehow, as she was bending down to help this woman, jumped up and bit her in very close to that same place. And so when she came home and told me that, I will tell you, I love dogs. I've had Dobermans my whole life. My wife had a Yorkie, although she'll tell you the Yorkie was mine and hers was a Doberman. But I can tell you that to this day, this was 10 years ago, 15 years ago. To this day, when I walk down the street and I see a dachshund, guess what I think? That little rascal. If it wasn't a little innocent creature, I'd wring its neck. And it's not even the dachshund. And so I know that I can't be fair and impartial to the dachshund. And so the way I like to look at it and talk about it is, if somebody called me up and they said, Dino, congratulations. We think so much of your work as a defense attorney, you're going to be the honorary judge in the dog show of Pasco County. I would have to tell them I would love to, but if there's a dachshund there, I can tell you that dachshund is not going to be one of the winners. If somebody asked me to do a calendar for a no-kill shelter, I would love to. I'll take photographs. Guess which dog is not going to be October or any other month? A dachshund. And so I know, even though I can be fair and impartial, that I should not be doing that. And so, I mean, I can mechanically look at the dachshund and say shiny coat, 7 inches at the haunches, 23 inches long. But I know that somewhere inside me, I couldn't do it. And that's why when I ask you these questions today, we talk about things, I mean, that's kind of the context to look at. I mean, part of this living constitution, which amazes, I mean, think about it. 220 years, this document, we're still living by it. Those first 10 amendments, they guide our life. We haven't changed them. We haven't gotten rid of them. So impartial and fair, that's what it is. It's your feeling. So when I ask you about, I won't say ill will, I'm just saying, do you have any kind of negative feeling towards defense attorneys? Do you?
No.
Okay. I almost said the name again. Number 42? Yes. There you are. Yes, Miss 42. What do you think of that?
I think it's a fair question to ask the jury,
Okay.
that everybody would be fair and impartial. I mean, this is democracy at its best right here.
Okay.
We all believe in it.
And so how do you feel? Do you have any kind of negative feelings or feelings towards defense attorneys, period?
No.
Okay. Does anybody have any feelings towards criminal defense attorneys, period? You can say you love them. It's not going to count against you. Okay. Well, and frankly, you know, as you go down the street, there's a lot of smiling lawyers with giving you their phone numbers. They want to help you if you get in car accidents. I guess there are not too many that want to help you if you get in trouble, so that's why I have to ask you that. Let me go through some more of these questions. Number 46. There you are again. Well, I'm going to talk to other people too. I'm not picking on you, but you asked a question, you answered a question, and what you said is dear to my heart. The question involved life experience being a volunteer.
Being a what?
Volunteer.
Yes,
And one of what you talked about is being a grief counselor.
correct.
Okay. And so tell us, as a grief counselor, what it is that you did.
We met with people who had just suffered the loss, and the people that I dealt with, it was usually a husband or a wife of older age. I was the primary caregiver of my mother, and the church recognized that based on my learning through the psychologist, how to be calm and patient and understanding, that I can be a very good listener, and that, so I took that course and I did that for a short period of time.
For how long?
About a year and a half, and only because things changed in my life that preoccupied me at work where it was more difficult to do it.
And more difficult because of the time demand or the emotional demand?
My demand in my job.
And I know a little bit about it. I'm not going to act like I know because I know. I know because, again, my wife did that in Miami Beach for like 27 years. And what she did was she would counsel, like you said, basically the living spouse of somebody who died. And it took an emotional toll on her after a period of years. And so I guess what I'm asking you is, in this case, what we're going to have is, we're going to have a deceased, we're going to have his living spouse. And so, going back to this whole idea of impartial and fair, and like I said, it's really something that comes from within, and again, you know, I know you've heard this, everybody keeps on saying there's no right and wrong answer. That's true, but really, it's not a question of grading you, it's a question of abiding by the Bill of Rights of our United States Constitution. And so I have to ask you these questions because although in our time, sadly enough, at the entrance to all the courthouse, there are these magnetometers. And so they can detect metal. However, they don't detect certain feelings you have. So they don't say, oh, you're going into that courtroom, courtroom D. Well, this is what the case is about. And so as you go through it, it sucks out all those feelings. And then when you go home, it puts them back in. It doesn't happen. And so my question to you is because of what you were involved in, the prosecutor termed it, are you the right person for this jury? And I think that's a fair way to phrase the question. And so let me ask you a little different way. Do you think that you can be a person who can take any experience you had out and not bring it back? And it goes into that thing that the prosecutor said is sympathy. You know, it's easy to ask a question, hey, you all promise not to have sympathy. Oh, yes, I promise. It's easy to do that, but I'm asking you individually because of your life experience. So tell me what you think about that.
I don't think I'd have a problem with that. This may sound cruel, but I somehow have the empathy to sit and listen to people, but I can walk out and party right afterwards.
Okay.
And I mean that in the most genuine way. It's that's what they need. They need a good listener. What happens with most people in grieving, everybody wants to tell them what to do. And that's usually not what they need. They need somebody to listen to them and give them comfort. But I don't take those things home with me or bring them into any of my personal situations.
And I know sometimes those people, especially some spouses, the other spouse took care of them to such an extent they're almost helpless. So I imagine you ran into people like that as well.
Yes.
So tell me some of the things that you would need to help them with.
Again, I was in a controlled environment, so it wasn't like I was in their home. They were in a church, and we were given guidelines to follow. And so the helping was more to whatever they may ask us. Our response wasn't to tell them what to do. Our response was more to question them back relative to what do you think you need. We were just good listeners to bring them to a point of peace that when they left, hopefully that would help them slowly, move on. Obviously, you never get over a death. That's somebody that's always with you. It's more about living with it in a positive way as you can, moving forward as quickly as you can in who you are as an individual.
Okay, so there are ways to, although the person may not be whole, in a manner of speaking, they can certainly survive.
Correct.
Anybody else involved in giving grief counseling or that sort of counseling? How about in receiving it at all? Did anybody ever have to go for any kind of grief counseling? Number 18, yes?
Yes, my husband, passed away in the line of duty, so I was involved in helping him obtain it. I felt like he needed it.
Okay. Appreciate you sharing that. I saw another one. Yes, 83?
My brother committed suicide and also possessed respiratory.
And so you can approach the bench and talk about it if you're comfortable speaking from there. Okay, all right. So let me ask you this, because you've been through an experience being close to somebody and going through that sort of loss. In this case, as I described, we're going to have, you're going to hear somebody talking that has suffered a loss. Is that going to cause you to have, I don't want to use sympathy because, everybody said yes, they wouldn't be sympathetic. But I guess, would you be able to somehow compartmentalize that and not have it interfere in your decision-making over there?
Absolutely. My emotions I don't really bring my emotions to other things that I present. I usually keep my emotions to myself, not like for work and dismissive and miss my faces and stuff like that. I into whatever situation I'm into to alter my view or my opinion on something in regards to that.
Okay. And I'm not nitpicking, but I am listening to you. And what I heard you say is that that you hold your emotions in. And so that means that when you go back there, they're still in. So you're not going maybe to express them, but I'm just wondering if that would affect your decision making.
No, that never affects my decision making. It's either black or white. It's not, I don't know how to explain it. Yes, it's not, it's something that's gonna cloud my judgment on what the facts need to be for a particular item, things like that.
Okay. And if it's not too personal, I'd like to ask you well, I'm going to ask you, I should say, if it's too personal, tell me you don't want to answer or you want to go to the bench and answer. Can you give us an example of a decision you made where you had to kind of hold in check your emotional part?
Well, yeah, it actually had to do with my brother. My brother suffered PTSD, and he was with the Tampa Fire Department for 30 years. So my family back in 2017 helped with workers' compensation to write a bill for the state of Florida for first responders to help get workers' compensation put in the bill for people who have PTSD. So when we were doing that, and especially when we were going through all the hearings to the Senate, to the state, through Congress, everything along those lines, we really had to keep our emotions to ourselves. It wasn't something where we could express to the panel when we're presenting this bill to them. It wasn't something that we were allowed to express to them what our feelings were. It was more the fact-finding on the fact of which workers' compensation did not cover for PTSD unless you had an actual injury. So now we have the capability of putting workers' compensation in there and for people to now have that counseling for first responders for them to cover that under the workers' compensation laws.
Well, so they recognize that it is an actual injury that doesn't necessarily have to be physical injury.
Correct.
Let me ask you this. So now you saw how the legislature works, huh?
Yes.
All right, you're seeing this, you're seeing that, so you've seen them make sausage, in other words. Tell me about that process. Do you think that the Florida State Legislature really tries to consider things when they make a law?
Absolutely. They have to take all aspects into consideration as to why this wasn't in the bill in the first place, or why it wasn't covered, and why it was only in a particular aspect. But then we had a lot of, people who have PTSD, but we had a lot of witnesses that their family members do have PTSD, and how it affects the family, how the emotional toll on it, what other things can go on with the particular families, like alcoholism, depression, addictions, things like that, that stems from that, from seeing. I mean, it's not just like you have to get injured on the job for you to have PTSD, like I understand with the military and stuff like that. But when you're going on the job on a day-to-day basis, and you're seeing bad things on a regular basis, it will take a toll on you. And you don't have to physically be injured in order for you to have those emotional stresses on your day-to-day life.
And so it sounds like to me that the Florida State Legislature just doesn't come in there and say, oh, we're going to do this or we're not. They consider a lot of things.
Correct. We had to rewrite the bill probably at least 3 more times, but we got it passed in 6 months.
And so I guess you recognize that the laws under which we're going to operate in this trial were pretty well thought out, right?
Absolutely, have to.
Anybody else have any experience, while we're on that topic for right now, with the Florida State Legislature and making bills and all of that kind of stuff? Anyone? No hands. All right, let's ask some more questions here. This one is under that training and education, that list of things. Let me see. Number 19. Oh, there you are. See, I'm looking at the right guy. Thank you. The prosecutor talked to you about you being a competitive shooter.
Yes.
All right. And it seems like you stopped in 2016. Was there a reason for that, or just ran out of time?
Just moved to Florida and really hadn't had time to get back into it.
Okay. And, oh, yeah, I did write it down. The prosecutor knows about that stuff. I don't, so I apologize. He said all action, right? Okay. I mean, to me, it sounds like you're running around or shooting from a horse or something. What does that mean? Huh? All action. That's all I can think of.
It's not from a horse.
Okay. But then is it running around shooting at...
It's running around, shooting at targets, recognizing targets, and so forth.
And that's like I've seen some training films where you're going through like a fake town or something like that, and silhouettes pop up? Or?
They don't pop up.
Okay.
They're in place. At least the range that I've done were already in place.
So you move from station to station? Is it, okay.
Yeah, it's done within time frames, so they judge you based off your time.
All right. I was dying to ask you. I wrote that down. No horses. I will be frank with you. I'm a little disappointed because I was imagining this, Okay. Number 42. There you are. Again. All right. You worked for now Judge Tepper.
No, I worked for,
Right. I should have said you worked for the now Judge Tepper when she was the then lawyer Tepper.
yes.
Okay.
That was a long time.
And you said she practiced some criminal law.
Some criminal, mostly civil, and I had worked for a criminal attorney in North Carolina and another criminal attorney in Elkhorn.
Okay. Anything about those experiences that would cause you, let's go to the defense, just talk about the defense attorney side, would cause you not to be an impartial and fair jurist on this? Okay. What about the idea that you worked for somebody who's now a judge?
Well, the criminal attorney had been a judge, so then it's now two judges.
Okay.
But then I went to work for the state of Florida, and I investigated child abuse. So I was working with more judges.
All right. Let's talk about when did you begin working with the state?
In 1984.
All right. 1984. It's a year after I graduated from law school, so when you do the math, that's a long time.
Yeah.
And how long did you work for the state of Florida?
The first time I worked for them for 5 years.
And let's talk about the 5 years. What did you do for them the 5 years?
I investigated abuse of the elderly, the disabled adults, and children.
Okay, let's talk about that. Tell me, is that part of the, I guess, it keeps on changing.
That was HRS at the time.
Okay. And then, is that the one that became Children and Families, or is that something different?
Yeah, and then it became DCF.
DCF. Okay. And is it something different now?
No, it's still
Okay.
DCF.
And so, tell me what you did in the first part of the capacity. When you say abuse the elderly, tell me what you're talking about. What does elderly mean under the law, as far as you know?
We investigated the abuse of the elderly, so the neglect, abuse, and exploitation.
Okay, and under the law, what was it, 65 years old? You're considered elderly?
Yeah, I think maybe back then it was 60.
Okay. 18 is shaking her head. Is it 65, 18?
Yes.
Okay. And so, you're considered elderly. Is that right, 18?
Yes.
So tell me what you did then in terms of neglect, which means it sounds like people not taking care of other people.
There could be self-neglect, it could be purpose, people intentional neglect. It could be abuse.
And by abuse, what sort of things are you talking about?
They could starve,
Yes.
Well, it was the elderly and the disabled adults, they were lumped together.
Okay, let's talk about the elderly.
They could harm them, they could starve them, they could steal their money, exploit them. They could deny them access to medical care. And so then I would have to file some paperwork in the court to get them protected.
All right, so it's like a
Kind of like
dependency, and I don't do that, but what I understand is that's when parents or some biological being is attached to a child, the state of Florida tries to take away from those people to take care of them?
No, when it's the abuse of the elderly, you're looking for people that are trying to exploit them, harm them, take over, abuse them. And so basically, you want to put them in an environment where they're safe.
Okay, and are the elderly, in your experience, people over 60 back then and over 65 now, are they more vulnerable as a class?
Yeah, well, they would have to be if the state considered it necessary to investigate them.
Okay, and do you agree 18? Is that, I'm sorry,
Yes, they're more
okay.
vulnerable to abuse and exploitation.
Anybody else work with the elderly? Okay, there, thank you. 81, tell me about that.
Well, I've been in the medical field since the 90s, done a lot of different things.
Tell me some of the things you've done in the medical field.
I was an EMT, and then CNA, and was going to fire school, but then got pregnant, but anyway. I am a CPC now,
What's that?
a professional coder, and.
Tell me about, what does a professional coder do? I mean, I kind of have an imagination.
You take doctor's notes and figure out how to bill that. Figure out exactly what the doctor did and how to bill it correctly.
Tell me then about your experience with the elderly.
I've worked in veterans nursing home.
Where at?
Hospitals, things like that.
Where did you work at veterans nursing homes?
I worked at the Colorado Veterans Nursing Home in Rifle, Colorado.
And what sort of things did you do there?
Everything, get them up, make sure they're okay and clean and shaved and get them breakfast, give them that. Make sure they're stimulated and their family can come and see them and that kind of thing. And then I worked at home health as well, so did some hospice work there.
Okay. And so that's the part where you have more hands-on with the elderly in the hospice work. You said EMT?
Yeah.
Tell me about that. What kind of training or education you need to be an EMT?
You have to get certified by the state and national or national. You don't have to be national, but
What do you need to do to get certified?
you have to take a certification college course that's set up for that.
Is it like a single course?
I think it was about 4 or 5 months, yes. That's one.
And as an EMT, was part of your training to like be able to diagnose people, for instance?
Not as an EMT.
Okay. What about any other time in your career? Were you able to diagnose anybody? Anybody else the elderly? I saw another card somewhere. Oh, number 29. Yes, 29.
Yes, I worked for the non-funded nonprofit organization that worked with the elderly, supplying them with supplies, talking to them on the phone, feeding them, not physically feeding them, but supplying them with food and meals, listening to them on the phone when they had problems and stuff.
And I was gonna, and I remember you said that, now that you say that. I mean, we've been together for 3 days, I probably should know everybody by now, but, I do remember you mentioned that, so I wanted to talk to you about that, and so we'll do it now, because I know it was on one of the other lists of questions. Is that like Meals on Wheels? I know that's what they have around here for elderly people.
Well, we contract with different companies to deliver meals to the elderly that can't afford the meals.
Okay, and what drew you to that, helping elderly people like that?
I was hired.
Oh, you
And
are?
I enjoyed it.
Okay.
Had to be certified with dementia, Alzheimer's, different prospects of the elderly. So I was a case aide, so there were times that I might have to go out into the home to do an evaluation on a client or something like that.
Okay. Number 27, I saw you shake your head up and down when I said Meals on Wheels. Did I get that wrong?
Yeah, I used to do Meals on Wheels. They're out of Hillsborough County on Hillsborough, which is west of the river.
Okay.
We just put in a big, huge facility. My wife and I would deliver it to the elderly that need the meals.
Okay, and that's just to help people?
Yeah, just to help. Yeah, they got on a list, however they got on it, and then we would, different volunteers would be the ones that would actually deliver it. So you're doing really a home check at the same time. So besides, just delivering the meal, you're making sure that they're going to answer the door and that they're okay, you ask them questions and so forth, and you leave them their meal.
Okay. Oh, 18, yes.
I hate dominating, it makes me nervous, but.
What is it, what makes you nervous?
Like dominating, I feel like I don't want to dominate
Well,
the discussion.
you're not, you're on the other side of the bench. I'm safe over here.
So during COVID
Yes.
times, I did go to the hospital and help the elderly for wills and things like that.
Okay. Thank you.
Oh, I just remembered.
Yes, number 42.
It was back, as we were talking about the elderly, there was a client or a defendant who had robbed a convenience store, and he was African-American, and he was given $1 million bail or bond, and the judge called me up and had me come to the courtroom and asked me to help navigate his well-being because it became like a national press thing, which he told me that I was covered.
Okay,
But, so I did that.
all right. Number 60. Here you are. I've been dying to ask you this question. When you said that you got counterterrorism training,
Yes.
so right away I hear training and counterterrorism all in the same sentence, and you're not in the military like these other gentlemen. And so I'm thinking, that's pretty interesting.
Of course. My husband got picked up to be a diplomat in Australia, but they trained 60 different diplomats, so even though we were not going to dangerous places, we have to take the class. So, yeah.
And so when you said your husband was a diplomat, he was in the Marines for 30 years?
He was in the Marine for 30 years.
Well,
and
I think
his
you're not
last-
allowed to say he was a Marine. You have to say he is a Marine, but he was in the Corps for 30 years. He probably wouldn't like you to say that, but
Yeah, he
okay.
probably was once a Marine, always a Marine, right?
Right?
So, yeah, 30 years, and the last 3 he was a diplomat in Australia.
Okay. And so tell me, what was his rank in the Marines?
Lieutenant Colonel.
And he was a diplomat. What sort of, like, was he assigned to the embassy there? Is that what it?
He was assigned to the embassy, yes.
Okay. 68?
Yes, sir.
I saw you smile when I said once a Marine, always a Marine. Did I get that right? All right. Number 71. Oh, there you are. Number 71. I just have to look down because we lost some of your prospective jury pool mates. And so I want to make sure the number I have is on my chart. Number 71, hopefully I have this next to you correctly. It's something about a disciplinary hearing for students. You conduct those.
I develop procedures for that. I don't actually conduct them. I have a staff member that does that. So we develop procedures and monitor those hearings and work with our school board attorneys to make sure that we're following all due process laws for students, making sure that families receive their due process rights.
Okay. So you said due process, and that's a wonderful word. That's in the Bill of Rights, right? And so when you say due process, what kind of due process do the kids get?
They have appeal rights. They have the rights to have the evidence presented ahead of time that will be used in the disciplinary process. They have the right to see any evidence ahead of time. They have the ability to bring witnesses with them of their choosing. They have the ability to speak their side of the story, present written statements, those types of things.
Okay. Which is kind of, from my perspective, kind of a twist on due process. Does anybody know where I'm going with this? Well, here's where we're going with that, okay? Does the child have a right to an attorney?
Yes,
Okay. Does a child have a right to testify or not testify?
yes,
Okay. Does the child have a right to cross-examine his accusers?
we would be very cautious of that. It's short of that. We have an independent hearing officer that monitors that, because we do have civility. So we do have a hearing officer that facilitates that process. So they do have the right to ask questions if they don't have an attorney, because most of the time there's not an attorney or an advocate involved. But the parent or student does have the right to ask questions.
And I see you,
It's not as formal as this.
but I see you emphasize ask,
Yes,
and you talked about civility.
yes.
Now, although, and we're going to talk later on more about reasonable doubt, burden of proof, and this whole thing, but when you said due process, I was asking because maybe that means something different to some people. So we were doing great until we got to the part where that they have the right to cross-examine witnesses against them, right? So they can ask questions. So it's a little different here, as you can imagine.
It is a little different.
And so certainly in this arena, in this cathedral of the Constitution, an accused individual has a right to have a jury make a decision. So it's a school board due process.
Yes.
Okay, so you didn't model it like after the Constitution or anything. Okay. Number 77. There you are. Were you talking about working with school children and de-escalating situations? Yes, tell me what you meant by that.
So basically, we're being taught how to, kids come in with factors from home, different factors that are occurring outside of school, so they teach us to try to recognize that, and when we see something building up in that student to, either remove the student, talk to the student, just different strategies to
Okay. And when you say release, what does that mean?
It could be a bunch of different things. It could be like just someone going against, banging their head against the wall, and, throwing chairs, throwing stuff at other classmates around the classroom. So it could be, anything. It could be shutting down, just sitting in the corner. Everybody's different. Everybody responds to different stimulus and situations differently.
Okay, so those are behaviors, correct me if I'm wrong, are those behaviors that build up over a period of time that you're taught to recognize?
Sometimes it could be over a period of time. Sometimes it could happen instantly. So it's just learning how to react, prior to or after and during.
Which is easier to deal with, somebody who's identified as potentially acting out over a period of time, or somebody who acts out instantly? When it's instantly, are you able to stop it all the time?
No, instantly. It's easier to work with people who you know more, know better, and you can see it coming. Because that way you can try to do everything to prevent it, as far as strategies or removing people or furniture or stuff that's probably going to happen. Call people to help you before it happens, as opposed to just all of a sudden something happens and then, for lack of better words, goes nuts.
Okay. And what age are these children?
Kindergarten through 5th grade. Some of them are, regular ed. Some of them are have disabilities like autism, Down syndrome, stuff like that.
Okay. The prosecutor told you can bring common sense, and the judge is going to tell you that. But the judge is not going to tell you that you can use your own personal expertise in deciding this case. In fact, she's going to say it is to the evidence and the evidence alone that you have to decide the case. So are you able to, let's say you see a situation, and then you're going to say, well, this sounds like something maybe that happened at school, and so therefore somebody should have acted in this manner or that manner, even though there's no evidence showing that, that was even in play.
Right, so what's the question?
So the question is, can you, put away your expertise in sort of what you're talking about?
Oh, yeah, absolutely. It's just, it would be based on, what is presented to me. I would make a decision based on what's presented.
Number 87. See, I did talk to somebody back there, didn't I? Number 87, I think you talked about being a behavior analyst specialist. Is that right?
Yeah, behavior specialist for Pasco County.
Okay, and so tell me what you do in that realm. What is your job?
Well, I'm retired now, but when
I apologize. Well, I'm happy for you.
It was to work with children. I worked with elementary school age children and pre-K who were having behavior issues, to try to determine the function of the behavior, what was driving the behavior, to write a plan that hopefully would address the function and provide that child with the kind of interventions to help them be more successful in the school setting.
When you say function of the behavior, what does that mean?
Well, you could say the motivation for the behavior. A lot of times, it's, the function might be they're doing XYZ behavior, they're seeking attention, or they're trying to escape from a non-preferred activity, or they're trying to access something they want.
Okay. And those are, you formulate a plan based on the behaviors that are presented to you, or do you do some sort of evaluation of the individual?
Yeah, the behaviors are presented to me. We do observations, take data, get together as a group and try to formulate a plan that can be done in the school setting.
Okay, and sometimes is there not enough of a pattern to have a successful plan? In other words, can somebody behave in in a way that's not expected.
Yes, that does happen. There'll be a severe behavior that is not part of the normal pattern for that particular child. But that usually is kind of a one-off, you know. You deal with that more as a crisis than something you would write a plan for.
Okay, right. That's what I was going to ask you. All right. But that was within your realm in terms of behavior that's interruptive. That's not a word. Behavior that's that kind of interrupts the learning process and the tranquility of the school.
Right.
Okay. I highlighted this. Who said crew serve weapon? Oh, the gentleman in the back. Is that number, thank you, 92. I was dying to ask you. It's crew serve weapon. When you said it, I know that you're a pilot. So I'm thinking whacking somebody with one of those carts, but I figure, well, that's not it. All right, what is that? What?
Anything like a M60, Mark 19, anything like gun-fed weapons that would require two people to keep the operation of the machinery going.
Oh, okay. So not like a professional wrestling, like not two people holding a clothesline or something across somebody's neck? All right, I mean, that's the only thing I envision. You're talking about heavy artillery. And so let's talk a little bit about that. You were talking about learning self-defense tactics.
Yes, sir.
And I guess when you say self-defense, are you talking about defending other people in the plane?
No, self-defense.
Just yourself?
Just self.
You're a pilot, what about everybody in the plane? All right, that's what they taught you.
I feel if I get to go home at the end of the day,
Right.
everybody else is going to go home.
You know? And I wish I thought of that, because if you defend yourself, I'm going to land in the plane with you. So let me ask you this. Were there certain tactics that were taught, because it's been a while since I've flown, since COVID. As I recall, the planes are kind of small when you sit in regular class like I do. The seats are kind of close together. The aisles aren't that big. So do you learn tactics that deal with confrontations in limited spaces?
Yes, sir.
Okay, tell me about that. Are there certain clues or certain things that are taught to you regarding, having smaller spaces, opposed to the gentleman that he's boxing, so it's a boxing ring. You know how big the boxing ring is, so, depending on his style, he's got room to maneuver. And so tell me about a plane. What difference do you think there is in defending yourself in an airplane as opposed to like a boxing ring?
You're not going to be doing roundhouse kicks.
Right.
First off, the flight attendants would actually deal more with the initial close combat, so to speak, and obviously we start with de-escalation tactics. As it gets to the flight deck, by that point, obviously things have gone horribly wrong. And if they breach the flight deck, we're usually strapped in, so we don't have any room really to stand up in here. So we are looking at what is available to use, an improvised weapon, be it fire extinguisher, a sunshade, crash axe, something of that nature. Generally, we would have a heads up because things are reinforced and there's certain things that I can't get into. But we have to say, okay, one of us is flying the airplane, because we have to fly the airplane. The other is going to worry about the defense of the flight deck at that point and what tactics we're going to initially start.
Would you agree or disagree with me that in an area that's a compact area, to use my gift of understatement, sat in some of those seats, let me tell you, I don't know how they do that. Some people should be charged for 2 seats, me probably 1.5, but anyway. And I always sit by, at any rate, is there some special consideration in the kind of pronouncement of danger? In other words, is it more dangerous to be in that small and confined area? Do you have to react more quickly, would you say? Have you taught that? Well, because you're inside the cockpit, so maybe that doesn't apply to you, but if they breach it, I guess it does.
I don't think, even as if say I'm just an extra crew member riding back, that confined area doesn't make you react any faster. Just as being in the air doesn't make us react any faster than we would if we were on the ground. You are trying to assess the situation. Every situation is different. As you mentioned, you can't just look at somebody and know right off the bat how they're going to be. There could be all kinds of situations. So we really work on what we call expanding our team and gather as much information as we can, and ultimately have to make a decision one way or the other on how that's going to be. We have methods for dealing with it.
And so the idea is that, number one, that it's easier to diffuse a situation if you have a bunch of people as opposed to just one person.
Not necessarily.
Okay. It's easier to defend a situation with more than one person.
I would agree with that.
And although in a small area, your reaction time doesn't change, is what you're telling me. It's the same reaction time. You don't react faster because it's a smaller area, right?
We probably, since 9/11, we have to pay more attention to keeping passengers under control, not getting involved in situations, just making a snap judgment, and then herd mentality taking over and getting out of control.
So prior to the catastrophe that you referenced, some things that prior would seem innocuous now might draw your attention.
I think the methodology is just different. You could say maybe before all that, it was more of cooperation as opposed to out and out threat. But again, every situation is different. You really, with our training, you are avoiding anger bias.
Okay. And what does that mean, avoiding an anger bias?
That you have a certain expectation of how something is going to go. So, as you said earlier, you're not going, oh yeah, I've seen something like this in the past, and you're spring loaded to go down that path. Just because it may initially look that way doesn't mean that that's how it is. You're constantly assessing that situation.
So unlike football, you see a certain formation, you kind of can guess what's going to happen. Your situation, you can't really guess like that.
Every situation is totally different. It's like if I fly from here to Miami, that's all I do with that. Every one of those flights is completely different.
Okay. And so what you're describing is you get in the plane and you're looking for things potentially that you could use to aid you in defending yourself.
I just look at the potential for a threat, and we discuss that with the crew. And if something does happen, we have the communication to establish what it is that we're going to do to respond.
Okay. Like, so every time you go into that plane, you have a plan for potential action.
Yes, sir.
Number 109. Nobody talked to you very much. I saw you shaking your head up and down when Mr. 89 was speaking. No, not Mr. 89. Mr. 92. Do I have that right? No, sorry. Mr. 92 was speaking. Tell me why you're shaking your head up and down. Okay. All right. Listen, you know, the problem is that as important as it is for me to talk to you all and ask you questions, you know, unfortunately, I get a little bit of a disadvantage here. I never could understand it. In trials, the judge speaks to you a little bit, and you know, Judge Barthel didn't really speak to you a lot. Sometimes judges will go on and on. The prosecutor gets to talk to you for 7 hours, and now, you know, you come back from lunch, and you gotta listen to me talk to you and ask you questions. And me talking to you all and learning about you, and you helping me to understand what you know is like the most important thing I do almost in this trial. And so I always get offended, especially late in the afternoon, that I have to put you all through this. But on the other hand, there's no other way I can do this. So now that I said that, let me ask you this. You're shaking your head up and down. Mister, I saw that you wore an Ohio State sweatshirt today. Yesterday you had an Ohio State shirt on as well. All right. Let me ask an easy question. Why is it you have an Ohio State sweatshirt on?
Well, I'm not from Ohio, that's
I know. You're not. This lady over here is. You're not from Ohio, but tell me why you wear an Ohio State University shirt.
So, I used to live in Virginia. The first 5 years of my life, I moved down here when I was 5. When we lived in Virginia, we had some good friends that lived across the street. They were family friends. And then they moved to Ohio when I was about like 2 years old. And after that, like a year later, they sent me a package of Ohio State gear stuff, and then
Okay. And in Florida, it only gets cold once every so often, so you know, I have sweatshirts that are like 25 years old. All right, let me see what other questions I have. All right. It was an unexpected segue. I didn't do it on purpose, but it works. Ohio State football. Mr. 86. Have that right? Okay. Prosecutor asked you about going to a Bucks game, right?
Yes.
All right. Who else has been to a Bucks game? I know a lot of people raise their, let me see cards here, please. All right, 83. Oh, see, I missed my opportunity. 109 went. Let's see how this spoken. 26. Let's talk about it. 9-2. You been to a Bucks game?
Yeah.
Where'd you sit?
Well, I actually worked the concession.
Worked the concession. Okay. Did you cart the stuff like up and down the stairs?
No.
Okay. Well, you worked at the stand itself? All right. You don't know what you're missing out on. When I was a kid, I used to work in the Orange Bowl with those Cokes, the big trays,
Yeah.
running up and down the stairs. So you,
Did you exercise that way?
well, it made better money probably to be behind the stands. Let me see, number 9. You've been to a Bucks game.
Yes, sir.
Where'd you sit?
50-yard line.
50-yard line. Okay, so you saw things pretty good, pretty well, right? Is that right?
Yeah.
But from your perspective, if the Bucks are going to your left and you're looking at the left tackle, let's say the line, I always watch the line. Do you see? Okay, I figured. Did you see the? Can you see the right side from where you're at all the time?
If I'm on the 50-yard line looking at the offensive line,
And they're right on the 50.
can I see the right?
Yep.
Yeah,
Okay. And are you high up enough to do that?
sure.
Okay. Are there certain angles where you can't see everything or everyone on the field?
Trying to figure. You can pretty much see everything from the field. On the field
All right.
at one time.
And so if you were, instead of a human being, if you were like a camera, the 50-yard line would be a wonderful place to be, right?
Sure.
Okay. Anybody not sit on the 50? Oh, now we're talking. All right, all right. Let me see, Miss We'll go back to Mr. number 86 since we started this. Yes, sir. Where did you sit?
I like to sit in the end zone.
All right. The corner or the,
I like to sit, I coach football.
right,
So I like to sit in the end zone because I can see the plays develop
right, you sit,
front to back. I can see both tackles, I can see everything, secondary.
right. So you sit in the end zone that's facing, you don't sit like in one of those angle ones, you sit right behind it.
I'd rather stay home.
Right. And I'd rather stay home, period, but, but that's a, 20 years ago, I would have gone. But so what you're saying is from your angle, your perspective, you can see a lot more
Yeah, you get a full 22 view.
than if you were on the side or not. So if you're a camera, you get that perspective that we see on TV. Here's the guard pulling, here's the tackle, tackling, going down on the.
Yes.
Okay, I got you. And so you do that on purpose, and you do that on purpose just so you can get the view that you want to get.
Yes, sir.
And if somebody said, I got a seat somewhere else, you'd say, I'm going to watch it from home.
If it's free.
Okay? Oh, if it's free, you'll go. All right. Ms. 83, where do you sit when you go?
We have season tickets in section 309, so where that is in the stadium, I'm not
Okay.
quite sure.
Oh.
I'm not a big football fan, but I like
Okay.
to go to the games.
Can you see every single thing on the field from your position, or?
Yes, where we sit, yes, we're able to, because it's kind of diagonal, so
Okay.
we're able to see the whole field.
All right. Anybody sit someplace where they can't see every single thing? Oh, there we go, my man, number 109. Okay. Now what, tell me what you see from up there.
I mean, you can see the whole field, but they're.
They're really small.
Yeah.
Okay. You have probably good eyes. All right. All right, here's an interesting one. The prosecutor gave you this example about, let's say the state had to prove that person A got married to person B. And so the only thing they have to prove beyond a reasonable doubt that person A and person B got married. Then they talked about flower children and this and that. And that's a pretty simplistic model, and I don't know that I have been involved in a criminal courtroom with such simplistic models. And so I have a concern about that sort of example and what your expectations may or may not be based on that. Let me give you an example. Number one, let's say it's a defense, just let's say, you want to get out of the marriage, right? Some things don't last forever. You want to get out of the marriage, and one of the ways to get out of the marriage is to say it's not really a valid marriage. And the law says, like it or not, the law says you can get out of the marriage if the flower girl dropped her flowers. Doesn't count. You're free. You can get out. Right? Now let's talk about that. The lady straight in front of me, could you hold up your card, please? Yes. Yes. Number 97. Thank you. The way this chart is, I'm just going to tell you the reason I asked that is because the way the chart is, it's hard for me to line up everybody, and I know the prosecutor is having the same problem I have, but short of taping the thing to your head, this is what we have to do. So let's say that's the example. The prosecutor said, well, you got 5 witnesses. They all saw something different, right? They saw something different. So if they have to prove, that the flower girl did not drop her flowers, wouldn't you want the stories to match up? Tell me what you're thinking about that.
So I can get divorced.
You don't even have to get divorced. The marriage doesn't count.
Okay, the marriage is.
So there's no money involved, there's no lawyers involved, no offense to my colleagues, we don't do that here anyway, but there's no lawyers involved, no judges involved, no offense to, no courts involved, no offense to the court system or the bailiffs or anybody. But, it just goes away. And so aren't you going to want everybody's story to match up? Okay,
So that makes it more difficult,
all right.
as a lot, people are saying different things.
Okay, and that makes sense. And prosecutor talked a little bit like that, and you see a car crash, four people see it, lights green, lights red, blue car, all that. And so, let's say that before the person asking the questions, let's say the police were called because there was a question on the wedding, and they wanted to do an investigation. So before they got there to do the investigation, that all the people in the wedding had gotten together and were talking with each other. Do you know, what do you think happens when people talk to each other about something they see? Huh?
They can easily get swayed. Oh, yeah, maybe that's exactly what happened.
Right, and so isn't that something you would want to know before making that decision?
Definitely.
Okay. Number 50. What do you think?
Well, if you're fully invested in what you're saying and taking in the information, you have to fairly take what was presented to you and be impartial with it. So it's a matter of taking in, understanding what's in front of you, and making those decisions based on that.
Okay. And so what about the idea that the people had gotten together before the investigator, the police got there? Are you going to be concerned with what their story is?
Well, again, it's going back to the same fundamentals, right?
Right.
Fairly and you have to be fair and you have to be unbiased, so you have to take the same information that is the bigger picture, the intricate parts, and making your assessment on those.
And when I was talking about the Bill of Rights, I saw you were shaking your head. Tell me why you were shaking your head when I started talking about the Fifth Amendment, the Sixth Amendment. You were smiling, shaking your head.
My daughter wants, her dream is to be a DA one.
Okay.
So we're training her up to be, grooming her, and she likes it, she loves it. She wants to be a judge one day, so.
Okay.
District attorney or judge, so we've been doing our homework, learning the roots of the country, the system, what this system means and what it does, and learning from it.
So you were smiling because you were thinking of your daughter. All right. And so I know she wants to be a DA, an assistant state attorney. No, that's a noble and that's fine. But let me ask you this, because you think there's something wrong with being criminal defense attorney? Okay. It's just what she wants to do.
Yeah, she has the title, but I mean, through the study of the Constitution and everything, she comes to appreciate, understand it, and she's only 15, so she's like, and we also, I mean, I wasn't born in the United States, I became a citizen when I was, 21 years old, but I was raised here. So to me, I understand it, I cherish it, I uphold it, I respect it.
And where are you from again? I'm sorry.
My country, I work
Yes, yes.
Colombia.
Okay. Anybody else Colombian here? No? Okay. Thought I'd check while we're talking about it. All right.
Mr. Michael, it might be a good time to take a break.
All right. Thank you, Judge.
We're about almost an hour and 40 minutes, or thereabouts, hour and 30 minutes. So we'll go ahead and take a quick comfort break. Everybody remember my instructions during the recess, and go back to the jury pool room and be prepared to line up again. Thank you, everybody. Okay, we ready to get them back in?
Yes, Your Honor.
How you coming along, Mr. Michaels?
No, I don't think I'm gonna be able to finish today.
Oh,
I know, and the other caveat that I would mention is that I know it's part of the deal, I'm the defense attorney, I get to go last. This is, I'm sorry, I apologize. I know I'm the defense attorney, I get to go last, it's part of the deal here. But, you know, in this case, they went through several hours of jury selection yesterday, and some today by the state. I think there were 7 hours in total. I'm not saying that I'm gonna take 7 hours, Judge. What I am saying is, I see some people going to sleep. It's not a personality thing, but I don't know why. I'm sure they're tired after all these days. I'm trying my best to, I even wore a bright colored suit, to try to keep their attention. I figured we'd be going late. And so one of the problems I'm thinking about is, I feel comfortable finishing today, maybe, at the end of the day, and coming back and tomorrow and finishing up, and because I don't know if I have anything else that Mr. Martin said that I'm going to go at. I have a list of my own questions that Mr. Martin didn't ask, and then I have some things we didn't talk about. We didn't talk really about burden of proof, only that I have the burden of proof. We didn't really talk about.
but you do not.
Pardon me? Well, I'm paraphrasing the state. We didn't have any discussion about it, but for the state saying.
Well, that's usually one of your things.
I know, so I have that thing. I have the civil, the things that I have left, the court is aware of, certainly. And so there's a significant, and we have to talk about the idea of justifiable use of force too. And so, and I would hate to have you here till 7 doing it.
Good Lord, we've just got to finish today. We've just got to finish today. We can't go another day. We cannot. I'm sure we've all done death penalty cases in less than this, or somewhere along the way. We just can't. We can't go another day. And if we do, we're gonna give up the rest of our panel. We're not. I can't bring in a panel of 50 tomorrow. And what if? Then what? I'm thinking tomorrow is our cushion in case we get to our final selections, even if it's at 5 o'clock tonight. And normally that part takes about 20 minutes. I know it's going to take at least an hour to an hour and a half here, but I don't care. We'll work to 6 or even 7 tonight if we can get this done. We've got to. Because if we have to go all over again in the morning with a new panel to get a couple more jurors, when else are we supposed to do that? Monday? Good God. We gotta stop.
I understand. So the court's suggesting a plan whereby we finish the jury questioning today, do our causes, hopefully have enough left over. Is that what the court is suggesting?
I want it done. I want selection done tonight. Tonight.
Judge, can I just make a suggestion? This is just we started at 1 o'clock. They had 7 hours of questioning. So, but let me just say this. We started at 1 o'clock, so right now we've been 2 hours into this. There's 2 more hours left.
Okay. Okay, that's fine. Let's do it. Let's do it in 2 more hours. And then we'll start our and then we get in the golden era where we're actually saying, I want this one, I don't want that one. That's the point I want to be at today. We have got to be there today. And yes, defense is last. What on earth left can there really be after, yes, 7 hours? But you guys also took at least often over 30 minutes per person individually. So where the state usually took 0. So it's definitely evening out. And all I'm saying is, no, I'm not looking at tomorrow again. I've been pretty, easygoing as far as, I would have thought Wednesday. I would have thought we'd have had a jury for sure Wednesday. So then we start back today. I'm thinking we're gonna be fresh and we're gonna get going. I figured he might go to lunchtime, which is where we're at. And you guys started at 1:10. So typically, by the time it gets to you guys, you do have a lot less to talk about, and you have already utilized a lot of your time, which I'm thinking ferreted out a lot of the normal cause issues right there in the individual voir dire. And I just can't wrap my head around the thought of telling these folks, you gotta come back at 8:30 tomorrow morning. Can't do it. There's no need for it. I know I've been present for Mr. Michael's voir dire more than once. And I believe one time it was a first-degree murder. Granted, it wasn't near the publicity, but, it wasn't a grand theft. So I'm just asking that you move it along a little bit. We've got to do this. Watch the clock. We've got to do this. I don't care if it takes you another 2 hours. I'm good with that. But we're going to finish. We are not going home at 5 o'clock and starting up in the morning with our selections. These people are going to know by the time we get done here this afternoon whether they're coming back tomorrow as jurors or whether they're done. So that's, we are getting a jury today. That's it. There's no reason we can't. So let's do it. Let's get them back in. Yes.
Prospective jurors in the courtroom, Your Honor.
Thank you. Mr. Michaels, go ahead.
Thank you, Judge. Oh, okay.
Thank you so much.
I've never heard that before. Who's having trouble hearing me? Okay. All right. I'll stay closer to the microphone. Is this better? Okay. I know Mr. Martin has some firearm-related questions, so let me ask you a couple that he didn't ask. I know that we had some members of the NRA. Show of cards, please. Member of the NRA? Number 31, that I remember, and number 105. And number 93, your husband's a member of the NRA. Number 31, why'd you join the NRA?
Help support concealed carry and other things that they were legislatively working for.
Okay, and do you get some kind of a magazine or something?
Yes, magazine, couple envelopes, you know, the stuff you don't put on your card.
I would think that's something you want to put on your card.
Not all of it, no.
Okay. Somebody else in the back here? Number 101? Your husband? 105?
My husband is a member of
And you moved here from New Jersey, is that right? All right. And was your husband a member there as well?
Yes.
And do you know why he joined?
He's just, I guess, he just likes to target you pretty much, and of course for, I guess, protection purposes as well.
Okay. Anybody here anti-NRA? It's free speech, we can all disagree. Number 18. Okay, why is that?
Not saying anti-NRA, but because obviously we have a lot of guns in my house, and my husband is law enforcement. And I don't think only law enforcement should have guns. So, not saying that. I do have a problem with anybody, anywhere, bringing a gun. I have a problem with that.
Okay. In this particular case, the scenario is that Mr. Reeves had a gun with him in the movie theater. And so, because you have that problem, and I understand that you're an attorney, and I understand you were a criminal attorney on both sides, but you're not, right now, although that is your profession, right now, you're a prospective juror number 18.
That's right. Agreed.
And so as prospective juror number 18, a person, should you be on this? If you think nobody should carry a gun?
No, I didn't say that. I just said, I don't think anybody anywhere should be able to, it's not a free-for-all. Like, there are certain places that should be restricted as far as where you can bring a gun in, so
Okay,
church, I think should be a restriction.
all right. What about movie theater? Because we had this talk when we talked about pretrial publicity.
Yeah.
And I remember your reaction was to that, you said, shouldn't happen.
Yeah, my first gut check is no. I don't think someone should be bringing a gun in the theater, but as you know, like I had stated, my husband brings his gun everywhere, like a little, those people who bring dogs around everywhere with them, that's like my husband with his gun.
Okay? So anything about that would make you not the right juror for this particular case? Your profession aside as a human being, because, I mean, frankly, we have to be able to make those calls and be frank with ourselves.
Yeah, and I'm telling you, like, as a human, not as a lawyer, because we can argue Second Amendment, like, all day,
I don't want to argue it.
Yeah, I mean, we can do it, if we really wanted to engage in it.
It's there for a reason.
See, it's hard for me to want to impose that, too, because I know the level of security maybe I feel because my husband has a gun.
Okay.
When I'm walking around with him.
All right, I understand. So,
I would be honest with you if I said, if I felt like I shouldn't be on this jury, but I feel like I should be fair and impartial and not carry that, as he had a gun in the theater.
okay.
And condemn him, I wouldn't do that.
Number 105, I saw you nodding your head. Is that right? What are your thoughts?
Like I told you, in New Jersey, that there was a lot harsher, and I'm less likely to be on a Walgreens line and have somebody in front of me with a gun in New Jersey as opposed to in Florida.
So the idea that more people have guns, does it promote better behavior?
That'd be a valid question, and, keeps me in check, for sure. I don't know about anybody else, but sure, I mean, I keep to myself, and I try not to, bend the rules in any direction, so that I don't find myself in a situation.
Okay. So based on the way you feel, still impartial and fair, or not the right jury for you?
I wanna say yes, I'll be, impartial.
All right. Let me tell you what concerned me, and I'm not picking on you, although it sounds like I am. I truly am not. When I asked you the question, you paused, right? And then you said, you didn't say I could be, right? You said something a little different than that. Didn't you say, what did you say? Do you remember? You can be. All right. So I thought you would say something to the effect of, that you would, or you hope you would, or something like that.
I don't want to be vague, I just want to just be, direct and say that, I love my country and I love the laws of this country, and I feel that everybody needs a fair shot at, and a fair trial. And, if I'm that person to be on the jury, I will be, giving, him a fair shot.
Okay. Number 101, I saw you had a facial expression. Tell me what you're thinking.
What I think is that, I'm not sure that this is accurate, but that the states that allow more guns have lower levels of crime in some instances. I'm going to carry a gun, probably will carry a gun, but I have no problem with other people carrying a gun.
Okay. As long as they're trained. Who feels more comfortable with somebody carrying a gun in a public place, including a movie theater, if they have training, if they have a lot of training? Raise your paddles, let me see. Can I have paddles, please? I appreciate it. Let me see, it's number 1. Oh, number 2, I'm sorry, moved over. Thank you, 5. I appreciate that. Number 2, tell me what you mean by that. Why is somebody with a lot of training better?
Well, if they've had the training, it's their right, according to the Constitution, to bear arms.
Why are you more comfortable with somebody with a lot of training carrying a firearm in public?
They know the safety and they know how to shoot.
Okay. What do you think, number 2? You're number 2, I'm sorry, I did that again. Number 5, I'll get it right. I called you 9, I called you 2. All right. All right, number 5.
I've been around guns all my life. I've seen people that go through the training and not necessarily understand the training of kind of how to handle a firearm or how the actual firearm operates. So when you go through these trainings, you need to make sure that they're comfortable with what they're doing. So, anybody go out and take training, pass a background check and get a concealed carry permit. Is it right? Probably not. But as the Second Amendment states in the state of Florida, you can do that. But you just need to make sure they're trained properly and they understand the training.
Anybody who doesn't have a carry permit who would feels more comfortable with somebody that's carrying in public if they have a lot of training? Paddles? Number 106?
Yeah. I'd like to understand what you mean by a lot of training.
Well, more than,
I would feel comfortable being around somebody that has a lot of training. I'm not nervous around these officers that carry guns around this place. To be honest with you, today was the first sort of exposure I've ever had to what goes into getting a CCW license. And I wouldn't consider that a lot of training based on what I heard. 4 hours, shot it once, and that could have been 5 or or 7 years ago. That doesn't make me super comfortable that that person knows how to use that gun in every situation.
Right, but as you said, if you see a police officer, you know that that police officer has had a lot of training.
I would assume they have a lot of training, know when to use them.
And you would be more comfortable with that individual carrying than somebody that shot the gun one time, got a permit, paid the...
Yes.
Number 91. That's you. Nobody talked to you. There you are. Tell me, what do you think about that? Let me ask you this. Are you afraid of guns? Okay. What do you think about an individual who's licensed to carry, carrying a gun in public?
Kind of like what he said. I mean, a police officer, I'm definitely comfortable with, but you need to have a nobody who's going around not knowing how to handle it. They don't know the safety's on, and then just accidentally pull the trigger. I mean, they have it in their hand and their fingers on the trigger, and that's obviously not good either, so instead of having it out and out.
Okay. Is anybody afraid of guns? Don't want to have them near them? Don't want to see them? Number 46. Tell me about that.
I'm not sure it's afraid, but there were a group of us together, and we happened to be with a police officer and a sheriff. Actually, the sheriff was in town from Miami-Dade, Florida, and they were all talking about who's getting a gun or whatever. It was when it's a time when the Fifth Amendment was in the news everywhere. And whatever expression I had on my face, they walked me through to realize I should never own a gun. So I don't know if I'm afraid of them, other than the fact that I don't think I could ever shoot anyone, and I just know I should never own a gun. And the sheriff, his wife was a detective as well, and she pulled me aside and she said, whoever you are in your personality, I'm just not someone owning that. I'm not afraid of guns. I don't mind the protection of other people having guns. I just should not own a gun.
And so in this case, because there's a gun involved, are you...
No, it doesn't bother me.
Does it bother anyone? No hands. All right. A lot of head shaking no, right? Okay. Here's a good question. Has anybody been to a movie theater? Raise it. All right. Let me see the paddles. Okay. I guess I can pick anyone. All right. Let me pick number 93. All right. When's it?
I thought you had an aversion to Florida State or something.
No. If you must know, that's where I went to school. So let me ask you this. What theater did you go to?
Grove.
Okay, where this happened. Is that right? Tell me why you go to the movie theater as opposed to, these days people have these gigantic screens and surround sound and all kinds of streaming and video feeds and all of that. Why do you go to the theater?
It's an experience. We
Te-
used to go to the Cinebistro, more so before COVID. You got big comfy chairs and people serving you, and it's kind of way out louder than I would ever have in my house.
All right. So you go because it's sounds like an experience?
It's an experience.
Okay. And what do you expect when you go to the movie?
Usually they have a good time, depending on the movie anyway.
Okay. It could be a good time with a bad movie.
Yeah, just to go and relax and, escape reality for a little bit, if you will, while you're watching the movie.
Okay. Let me ask, I saw, and I haven't spoken to this gentleman, let me see. Is it number 59? I have it right. Yes. You go to the movies?
It's a rarity.
Okay, and why do you go when you go?
It has
Okay, and that's an interesting term you use, having experience. Tell me what you mean by having experience.
It's fun to sharing something together, out and about, and nowadays, you're correct, like, you can just sit at your house and watch something, but to go out to a drive-in or to an actual theater, it is an experience.
Okay. Anybody ever see any kind of disturbances in a movie theater? No? Oh, there we go. Number 83.
It was basically just people talking during the movie, like like if you're watching a scary movie, it was just kids, teenagers, just talking, unfortunately.
Okay. And number 50?
Yeah.
What did you see?
I mean, you hear the occasional, be quiet, don't do this, don't do that, turn it off, kind of a thing that you either hear or you have to say yourself sometimes.
Okay. And that's it, nothing else out of the ordinary? When you go to the movies, do you expect everything to be just kind of like, even though the other people there, it's just like you're there with your wife or children or whatever, right?
Yeah, I mean, you go for the experience, or my family, we're movie buffs, so there's a premiere of a movie and we want to go and hang out at a theater, that's what we go to. We also go to the Grove, so it is a fun place to be at.
Is there something exciting when it gets dark inside of the theater? Why is it exciting to you?
I guess the sound is way better, even if you have a surround system in your home, it's still way better in the theater. The screen, bending the format, things like that.
Okay. Number 59. I saw you made a little motion.
Your question on disturbance in the movie theater.
Yes.
I'm pretty sure I was a child, this happened maybe middle school, but, what they say happened is some teenagers went outside and started setting a fire outside the movie theater, like emergency exit. And so people saw smoke coming in or smelled smoke inside the theater. Again, I was a child, but to answer your question,
And so did you have to evacuate the movie theater?
I don't believe so.
Okay. That's one of those First Amendment questions they always ask you, oh, free speech, but you can't yell fire in a movie house, that kind of thing. So again, you lived the Constitution then, even before today. Okay. Anybody else? Anybody been involved in a fight? Not just it's planned. I'm going to spar with you. You're going to spar with me. We know it's going to happen. Or number 9 is going to practice mixed martial arts, right? So you know that I'm going to go hands-on with this guy. Anybody ever get in a fight, a physical fight that is, that was unexpected, that you didn't plan ahead of time? Number 81.
Domestic violence.
Okay, so it was hardly a fight then.
Well, I tried.
Okay, all right. Anybody get in something, a different sort of, yes, number 18, and,
At church camp.
okay, at church camp.
We completely beat the crap out of each other, both of them.
All right, and so did that happen pretty quickly, or was it building up over time?
No, it built up. It got really bad.
Okay,
I think I got knocked out
oh, with a fist? Oh,
Yes.
okay,
over my head.
oh, all right. Number 59, you're a youth minister, right? That doesn't happen at your camp, does it?
I don't think so.
Okay. And I saw another lady, number 40.
I mean, I've been like girl fights, like cat fights in high school, like that happened pretty fast. But yes, I've been punched and I've like punched other people.
Okay, and when that happened, was it unexpected that it went from did it start with words? Let me ask you that.
I mean, yeah, like catty girl stuff.
Okay. And then it escalated to
Yeah, shoving and then hitting and hair pulling.
anybody else maybe not. Number 50.
Well, growing up in New York City, I DJ'd a lot and I hang out with the wrong crowd. And unfortunately, when you hang out with the wrong crowd, it attracts, bad stuff
Okay, and so, what you're saying is, you would try to make a judgment call right there if you could fight or if you had to get out of there?
Yeah, I mean, most of the guys that we hung out with, we did MMA, so we did have certain green belts and things that you don't want to use. And if you do, it's mainly incapacitation or just stopping somebody. And sometimes we did have to use that, especially in the club, for people that got rowdy and stuff like that. Different instances, different things.
Okay, 59?
Is there an age limit on this question?
No, there's no age limit.
When I was a child, I grew up outside the country for a few years, and I just got picked on a lot, trying to draw attention for compassion or anything. But again, I want to be forthcoming and honest.
And where did you grow up?
In Honduras.
And so, when you say you got picked on, that sounds like you were bullied. I mean, that's the word now.
I was an American, and I was growing up in an environment where I didn't fit in. So there was some level of trying to fit in and getting picked on and getting in little fights.
Okay, anybody else get bullied in their life? Number 18. Yes? 81? 18. 81, okay. It was turned the other way. It's all right. 81. You should put a line underneath.
Same kind of thing. As a child, I went to a school that was really bad in Orlando and was bullied quite frequently.
Okay. And how did that make you feel?
At the time, as a little kid, just unliked, why don't they like me? You don't understand. Why are they being so mean?
Was it physically bullying you?
Yes.
Okay. Anybody else physically bullied? 93?
Most, from the day I stepped into kindergarten till about the day I stepped out of high school.
Okay. So you went through bullying on a regular basis. Physical bullying?
Yep.
And so,
Got back to school bus. That's not fun. So, yeah.
all right. And did you wish you could somehow fight back or stop it? Pardon me?
Absolutely. I did it one time in high school, not physically fought, but verbally fought, and the boy cried and never picked on me again. You learn to hold your own eventually, yeah.
Yep. Number 47?
I wasn't bullied myself, but a good friend of mine was. She always wore a brace on her leg, and people would ask to pick on her, so one day I walked up behind a group of people that were tormenting her and grabbed their hoodie, spun them around, and said, "Don't ever pick on her again," and they never did.
Okay.
They just needed to be phased off.
Sometimes you have to stand up to a bully, right?
Yes.
Here's a question. We'll make it in two parts. Number one, who here is over 65? 65 or over? Numbers, please. All right. Number two, I'm not going to ask you how old you are. But what I am going to ask you is, do you think you can physically do everything today that you could maybe 10 years ago? Okay, what are some of the things that you can do?
Well, I worked for the Postal Service and I had to do a lot of lifting. I can't do that no more. Pushing and pulling, I can't do that.
So physical limitations?
Yes.
Do you feel as confident in terms of your physical just well-being every day?
I'm sorry.
Do you feel as confident as you did back then in your physical well-being, or do you kind of have like a recognition that maybe you're maybe a little more vulnerable of a person than you used to be?
Be more bond.
Now, why did you get your carrying license?
I lived in Sumter County and I would ride my bike. And Sumter County police officer
building up and everything, so I put in the budget.
All right, so personal protection.
Yes.
I guess you couldn't physically fight off people, right? Also, first row, I'm sorry, 65 or over. Second row, number 42.
Oh,
That's you?
um.
Tell me,
fine.
okay, can you do everything you could 20 years ago?
Actually, I think I can do it a little better. I have a bum leg, but I took ballet for 3 years, 3 times a week.
Okay.
And I seem to have actually ended up better.
All right.
And I like to write, and I think that's good to keep your mind sharp.
All right. Next down the line, number 33.
Yes.
You look like you're in good shape. Tell me, do you, I see that. So tell me, I mean, you do the Ironman, is that right?
Yes.
Okay. Did you do that 20 years ago?
I did it 3 months ago
Okay. When did you do the first one?
in 1987.
Okay. So you're a long time fitness buff,
I've been doing it 35 years.
a triathlete.
The full Ironman, yes.
Okay, the full Ironman. Where they finish up with the 26.2.
Yes.
Right. I can never understand that, to get off the bike with your legs feeling like they do over 100 miles and then run a marathon. So I guess that's an unfair question for you, or is it a fair question? Do you feel in any way that you're more vulnerable than you were 20 years ago, physically?
I'm slower, but I'm not, I don't think I'm any more vulnerable now.
Okay. Well, you're an Ironman. Do you have friends that are your age, that you?
Not anymore, no.
Okay, well, because you're around all the younger ones that are doing Ironman. I see. When you say not many more, is because they're,
As they've gotten older, they've changed their routines and they're not doing it as much.
okay, so some of your friends that are your age have slowed down because of their age or lack of discipline, I guess?
That and physical ability.
Okay, because sometimes people can break down, not everybody can run for all those years without having their knees, hips, feet, right?
I've been blessed.
Okay. Number 31, same question to you.
Well, I would say yes, I feel more vulnerable as I've gotten older with knees and hip problems, but I would also say I think I'm a little smarter and more observant when I'm out and about than I definitely was when I was in my teens and 20s and young and dumb.
And so, you know, that was going to be my next question, and so let me ask you a little bit more about that. You don't put yourself in all the same situations, or what is it that you mean by that? Are you just more careful, or you realize your capabilities or lack thereof?
I guess there's probably some things that I wouldn't necessarily attend that I might have when I was younger, but you know, you park in a parking lot, you're more aware when you walk to a store and back, your surroundings, same in the store, so if you sense somebody's coming up behind you, you move over to the side and check. So just more awareness when you're around people and places and all different areas.
And did you get your carrying license for personal protection?
Personal protection and I think public protection in general.
And what does that mean? You carry it in public to protect yourself from what might happen when you're out and about?
If something would happen, there's so many shootings that do occur these days. There may be a time that you may need to use a weapon or have a weapon to stop other people from being harmed besides yourself. There also is probably other situations where you should never use it because there's too many other people around and the situation doesn't deserve it maybe. It doesn't look like anybody's gonna get hurt, let the robbers leave, whatever. So I think it's a strong responsibility when you carry a gun and you have to use judgment.
Okay. And you're a hunter and all of that, so you look pretty tough. Do you think you can, take a punch like you used to, or?
Talking to me?
Yes.
Take a punch like I used to?
Yeah. All right.
Probably get blown over easier, yes.
All right. And let me see, that was number 29? Yes. Tell me about feel different, feel more vulnerable, some of the same questions. Feel older?
Don't have as much strength, you know, just more aware, like he said, when I'm out at a store or something, the parking lot, watching people and, you know, just to be safe.
Okay. The next row, 3? 65 or older, I know, I'm sorry, 46. Same question.
I've lived my life in moderation. I pretty much can do everything today that I've done pretty much all of my life. So,
Okay. During your life, did you ever do anything like the Ironman, like this gentleman?
no, I do hike a little bit, bike a little bit. It's just really for some physical exercise. I should at least be doing every day, but nothing extreme in any way, shape, or form.
Okay, so even your physical endeavors when you were younger were not extreme, they were in moderation as well, is what you're telling me? Okay. Anybody else in the third row? 63, yes? Same question.
Okay, my mind is still sharp, but the only thing is I walk with a cane, but I'm still working full-time at 70.
Okay, and why do you need the cane?
I have a bad back.
All right, so without that, you would fall over.
Yes.
All right, and the cane's working, because I haven't seen you fall yet.
Right, the cane's working.
Let's go to the next row, number 4. Nobody. Number 5. Number 87.
Well, I mean, what I notice is I play tennis, I'm not as fast, I don't have the same pop on my serve.
Okay, little things like that, but you stayed active.
It's quite annoying, yeah.
Okay. Aging is annoying. I thought you were asking me. Yes, it is. Next one down in the row. Number 101.
Definitely not as fast as I was, but I also don't have better risk assessment for the things that I do now than I did 20 years ago. But I'm very active and probably in better shape than most women my age. Because I raise cows and
You raise cows? Are they numbered? No, I'm not just asking. I learned from someone that I don't know. So they all have numbers, right? You don't have a 101. Okay. And so let me ask you this, 101. You talked about risk assessment. That's it. Isn't that the term you used? Tell me what you mean by that.
when I was younger, I just didn't worry about stuff very much, didn't really think about what might happen. Got myself in some sticky situations that were kind of scary. And thank the Lord, got out of them. I would not do the same thing now.
Okay. Similar to what we heard about from number 20. Well, he had that. He went to St. Pete with some friends, and when he was young, he would never do that again.
On a bicycle trip by myself and was stopped by a person in a vehicle. It was a very lonely area, and in that situation, I wish I had a concealed carry permit and gun. It's quite frightening.
Okay. And so you would make different decisions now with your experience than you would when you were young. Let's talk a little bit about this this idea of presumption of innocence. Presumption of innocence. Anybody have any thoughts? What presumption means? Don't be shy. It's getting late. We can. All right. I can call on somebody. Number 59, presumption.
Let's say to come to a conclusion about something before seeing all the facts and evidence.
Okay.
Conjecture.
Okay, number 60, what do you think about that?
Assuming.
Okay. And so in this case, we have a presumption of innocence, right? What does that mean to you, number 81?
It means that he is innocent until we get all of the facts and the evidence together and determine what those show.
Okay, and let's talk about that idea. How does, number 67, how does a person lose this presumption of innocence?
I am proving that they're guilty.
All right. Well, and that's right. What happens is, if the state proves beyond a reasonable doubt, as a juror, you make the decision if the person loses their presumption of innocence. In this case, number 19, who has the presumption of innocence in this case?
Who has it?
Yes, sir?
Yes, defendant.
Right, Mr. Reeves, right? And you said defendant, so that's interesting. What do you think? Number 33. What do you think about when you hear the word defendant? What does that make you think?
That's the person who we're trying to defend the accusation against.
Okay. So you use two good words. You use accusation. That's a good word. And so a defendant sounds like you have to defend something, right? Like he has to do something to defend himself. Is that what you think?
That's what the word would imply, yes.
Okay. And so in this case, the interesting thing is, under this Constitution and the law, an individual that's accused or presumed innocent, Mr. Reeves, doesn't have to defend himself, right? Does anybody have a problem with that concept? You know, it makes sense. We have teachers here. You hear one side, you hear the other. He doesn't have to defend himself. He's accused. Anybody? Mr. Haney, can you hear all right without those headphones?
Well, they're irritating my ears.
All right. And so I saw you were taking them on and off. Can you hear or not really with those things?
Not good because they hurt so bad and takes all the attention away from hearing.
All right. You take them off so they won't hurt? But can you hear them when you take them off?
A little bit.
All right. All right. Because I saw you rubbing your ear, so.
As long as you speak up.
All right. If I don't, you raise your hand. Have you heard every single word all of us have been saying?
Some of it, yeah.
All right. Number 77, what do you think about that idea? He's a defendant. It sounds like he has to defend himself. He's really the accused, according to the Constitution.
Right, so you're basically, I mean, innocent until proven guilty, I guess.
Well,
You can't really make an assumption on anything until you know everything.
all right. But the only way you'll know everything is what?
By getting both sides of the story, like, you know, if one kid says, hey, he punched me, what am I gonna do? I'm gonna go ask the kid that he's accusing, hey, what happened? You know, I have to hear both sides of the story, sometimes the third side, just to figure out what's what.
Okay, so let's talk about that. In the United States of America, in this courtroom, you don't have to hear both sides of the story. Again, it's human nature. We talk about, and I hate to use that because I know you want to be fair. I know you want to be impartial. But the idea here is that the person that's accused does not have to give you his side of the story. He has a right under the Fifth Amendment not to say anything or be forced to testify. So what do you think of that idea? Is this maybe a criminal case isn't the best one for you?
Well, it's not him personally that's defending himself, it's you.
Okay.
So therefore you are, I guess, in essence, defending him, right? Or he's defending himself for you.
Well, that's an interesting question. I think that's a good question. I think what the law says, he has a right to counsel, which is what I am, to defend himself against the state or the government. But he doesn't have to prove anything. So is that a problem for you because you want to hear both sides? I mean, it's a natural thing to want to hear both sides.
No, I guess it wouldn't be a problem for me, but I don't see how that wouldn't happen.
I understand that, but you understand what I'm saying, where I'm coming from, because if you go in with expectations and then he doesn't testify, you're telling me you guess you could.
Well, I mean, I would have to go based on what is presented. I would have to make a decision based on what's presented, how I feel about what was presented by the other side.
Okay.
The side that is telling the story. And I would have to go off the knowledge that I know.
Okay, anybody think, so you're not gonna have to hear both sides?
I mean, I guess not.
Well, you know, okay, so if you hear one side, you're gonna go with what they say because you only heard one side.
Well, no, I'm gonna hear what they say, internalize it, think about it, and then come up with a decision on what I feel is the best decision in my brain.
Okay. And so you'd like to hear both sides?
Yeah, I mean, it'd be nice to make an informed decision on, all the information that's available.
And if you don't hear both sides,
If I don't hear both sides, I don't know. I guess I would just have to go with what I know.
all right.
What number is that, 77?
Anybody that would need to hear a second side? I have to hear two sides to it. Number 26,
So technically, he's not required to defend himself?
he's not required to testify or to put on a defense,
Right.
right?
But if he doesn't, then that makes the prosecutor's job that much easier.
Well, the prosecutor's job is to prove, it's always the same, to prove beyond a reasonable doubt that he's guilty. So-
Since you compare it to a football game, if the defense doesn't do anything, all the offense has to do is just walk across the field and score.
Well, under the laws of the United States, remember, he's presumed innocent.
Yeah.
So that means that if you go on the field, the offense is on the field,
Yeah.
the defense isn't there, right?
Yeah.
The defense is presumed the winner. In this courtroom, we're the winner, presumed innocent. And so if the offense just gets on the field and runs around, we still won, because they didn't prove anything.
But then the offense should walk across the field and score.
Okay, that's true. That's true. I don't know under the Constitution if the score would count. I mean, I don't know,
All we have to listen to is the prosecution's argument
right?
without hearing the defense's argument.
So if you don't hear the other side, if we don't put on any evidence at all, you're going to find him guilty.
What else do we have to go on?
Okay. All right, so that's what you're saying. Is that right?
That's why you provide defense.
All right. Okay. Do you understand you know what I'm asking, right? I'm not trying to trick you. I just need to know that if you understand, because the prosecutor talked about this burden of proof.
Yeah.
That means they have to prove that Mr. Reeves is guilty beyond the exclusion of every reasonable doubt.
Right.
Okay.
But if you're not providing any defense, then that makes it easier for them to rid us of any reasonable doubt.
So you would,
Isn't it part of your job to help provide reasonable doubt?
yes, but it's not necessary to put on a defense or have the defendant testify or put on any witnesses.
No, not necessary.
Okay, so if we didn't, are you just gonna say they win because we didn't do anything?
Not necessarily, but it does make their job easier.
Okay. Anybody else gotta hear both sides? Or they win? Number 106.
I mean, I'm gonna presume that every witness is credible and telling the truth. So,
Yeah.
All that thought.
Recess, be right back at the jury pool room and ready to line up at 10 after, okay? So we can get started and hopefully, get to a good point today, okay? Remember my instructions during the recess. All right, they're lining them up. I know. Whether or not they need to make phone calls. Mr. Michaels, how are you doing with time?
It'll be after 5.
Okay.
I don't know that I can finish in 49 minutes.
No, that's, I indicated, 5 o'clock. Can I tell them to make some phone calls and we're liable to stay till 6? I don't know how we can go, how it can take terribly long, our selection process. If we run out, we run out. That's not my concern, and that's not why I had such a meltdown earlier. Tomorrow, we've got 50 new ones, and I just don't want to. We've worked these people over for 5 days now, or 4 solid days. 4 solid days, many of them. And, and there's, I just don't want to bring them back again tomorrow. If we run out, if we can't get 10 out of this bunch, then so be it. We'll start all over again with the 50 we got and get a couple more, whatever we have to do. But these guys have been troopers, and they've been through the ringer, and I just can't see bringing them back again tomorrow. Unless, only the ones we need. And even then, if we can't get 10, we're going to need to spend time. We will have to start on the new 50, because look at how long it took us to get to this point to where we're even, look at all the things that we've got to go through with another 50. I'm looking ahead. Will we be able to get any more tomorrow if we don't get them all tonight? We can, that's hardly realistic in light of the fact that here we are at Thursday afternoon and we haven't gotten a single one. So to go through all of this process with 50 tomorrow is not likely. So if that's the case, then we're pushing into next week. And I don't know about you guys, but I'm very protective of our last 2 weeks, 10 days that we have. I had absolutely zero intention of anything but solid trial during that time. And only, we've got outstanding motions. They'll have to be done outside the jury's time. And I don't care if we do them, at 10 o'clock at night, but we're not doing it. It's not cutting into our 10 days of trial. We can't. In my experience of going through the prior hearing, 10 days we're pushing it. We have zero cushion. So we have to get this done. We have to. And that means we have to finish this tonight and see how many we can get. Because if we have to use any tomorrow, we're going to be here all night. But we still have, we've got to get a jury by tomorrow. Period. That's it. So do what you can do. I'm going to tell them to make a phone call if they need to. Just tell them that we might be looking at 6 or later. 75, 70, yeah, 75.
Carrie, I'm sorry, 75.
Yeah, 55 is already gone, I think.
And they're going to line them up against the door? I had already told him the numbers when I went over there.
Yeah.
Ready for the jurors, Your Honor?
Yes,
Prospective jurors enter in the courtroom, Your Honor.
thank you. Thank you, Deputy. Were you all able to abide by my instructions during the recess? All right, and I'm sure you got the word that we may work a little late, but we're all doing our very best to, do the best by you guys, so hang tight. Mr. Michaels?
Mr. Peterson, we're talking about presumption of innocence, and I saw you, maybe I misread you. Did you want to say something about that? What are your feelings about the presumption of innocence?
Well, when you were asking the question, does the defense have to prove something? No, because they've got to prove, if they can't prove to me that what they've got to present proves that the person's guilty, then I can make a decision on just their presentation.
You can't.
I can't.
You can.
I would hope so. If they can't produce enough evidence to convince me that the person is guilty, then yes, I can make a decision without hearing any defense.
Okay, I understand. I got you now. You could make a decision if they don't provide evidence beyond a reasonable doubt that Mr. Reeves is not guilty.
Without you making any decision.
Without doing anything. Right. And I know you're shaking your head back there, number 81? Do I have that right? Oh, I do. So you agree with that?
Yeah.
You're shaking everybody? Anybody disagree with that? Anybody have a problem with that? That the defense doesn't have to do anything? Defense is a misnomer, it's the accused? Okay. Now, let's talk about, the state talked about burden of proof. It makes it sound so horrible. It's a burden. It's something that's weighty and all of that kind of stuff. Well, frankly, the burden of proof is what's required when you're trying to deprive an accused of his liberty. And so the state's burden of proof is beyond a reasonable doubt. I know that some people were, or a couple people were in a civil jury. Who was in a civil jury before? Anybody left? No. All right. Let's talk about that. Anybody involved in a civil lawsuit? Okay. Your number, please?
Oh, I'm sorry,
33. Tell me about that.
misdemeanor.
Okay, but that's a criminal matter.
Oh, I'm sorry.
Okay, anybody in a civil lawsuit? Okay, in a civil lawsuit, you have two parties going at each other, like a football game, kind of. And in order to get money, saying one party's more at fault than the other, that's a preponderance of the evidence. So all those guys that you see on the billboards that are smiling and want to help you if you've been hurt in an accident, they have to go to court and prove by a preponderance of the evidence, 51%, not even 51, a little more than 50%, that the one party has to pay the other party money. In a criminal case, it's beyond and to the exclusion of every reasonable doubt. And the judge read you that instruction. The judge told you that a reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if, and here's the interesting language in this whole thing, if you have an abiding conviction of guilt. An abiding conviction of guilt. Number 50, what do you think about that? What does that mean to you, an abiding conviction? All right, let me read you the whole definition of reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. So what we have here is we have an instruction that's essentially telling you that to convict somebody, you have to have an abiding, and then for some reason they use the word conviction, an abiding conviction of guilt. Then the instruction tells you that even if you have that conviction, you can be convinced, have an abiding conviction of guilt, but even if you have that conviction and it wavers, you must find somebody not guilty. Is that?
Excuse me, Judge, I object.
Sustain, rephrase.
Can anybody tell me what that means? That they just heard? Number 50?
I guess I'm objecting everything that we just discussed, whether or not they can follow the law.
All right.
All right, number 50. Do you understand what that means? Or does it sound a little confusing?
It does sound a little confusing, so would you mind dumbing it down a little bit, or just giving two examples, like example A, example B?
And so one of the things that I'm not allowed to do is, because I'm not a juror, so, and I'm not allowed, because the problem with that instruction is that, in terms of definitions, there isn't one. And so I'm not allowed to give you a definition of those things.
Okay.
The court's not going to give you a definition of those things. The court's going to tell you that's what it is and to go back there. I'm going to come back to you, we're going to talk a little more. Anybody else want to crack at it? What does that mean to you? An abiding conviction of guilt. Anyone? Number 97.
Excuse me, Judge, I mean, we're back to the same thing. It's not working.
Number 97?
I feel that if I have any doubt in my mind from the evidence that I've seen and heard from the prosecution, he's innocent.
Okay. And so here's the punchline. So then it says in there, if you have an abiding conviction of guilt. So that's the other side of what you're saying. You're saying if you don't have an abiding conviction, he's not guilty. That's pretty easy. So then it goes on to say, if there's not a abiding conviction of guilt, which is the other side of what you said, he's not guilty. That's what you said. Or if having a conviction, in other words, you have an abiding conviction of guilt, but it wavers and vacillates, he's not guilty. Okay. Crazy concept, number 27? Or is it a good concept?
I'm falling back to the whole thing at the beginning where, I mean, if the prosecution is going to present their case and the evidence presented to me, okay, shows me without a reasonable doubt that the individual is guilty, then that would be the case. If it's not, then it would not be.
Okay. But that's what beyond a reasonable doubt means. In other words, you have this abiding conviction, right? So they have to prove you to that level.
Right.
But even if you have that, but it wavers and vacillates, that conviction, that abiding conviction you have, he's not guilty.
What's waivers and vacillates?
Right, exactly.
You get to a point where.
Right. So let me ask you this. If you got back there and the instruction has uses that kind of phrasing or whatever, those words, is that something that, because if you don't understand it, you're not going to be able to follow it? Okay. And so how would you go about being able to understand it?
Because I understand the fact of presenting the case, they're going to present, if they cannot present without a reasonable doubt.
Okay. And you would just say, you have your own idea of what reasonable doubt is? Yeah, I'm sorry. Yes? Okay. Anybody can't do that. You have abiding conviction, but it's one that wavers and vacillates, he's not guilty. So on one hand, they kind of gave you evidence, right? Number 60? Enough evidence that he's guilty, but they're saying, well, if they give you enough evidence, but you're going back and forth, he's not guilty. Can you do that?
Yes.
Okay. Anybody think that's too much? Can't deal with it? Okay, no show of hands. An issue in this case is going to be justifiable use of force. And so I'm going to ask the court, read you that jury instruction because we need to talk about that a little bit. Do you mind, Your Honor?
Approach just a second, don't worry. I don't know. We won't know for a while.
Okay. If the court wishes to read the jury instruction, or if the court wishes me to do it.
No, I'll go ahead.
Thank you, Judge.
And ladies and gentlemen, this is the actual jury instruction that I'm about to read. Justifiable use of deadly force. An issue in this case is whether Curtis Reeves acted in self-defense. It is a defense to the crime with which Curtis Reeves is charged if the death of Chad Oulson resulted from the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. The use of deadly force is justifiable if Curtis Reeves reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting an attempt to commit an applicable felony upon him. A person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or another, or the imminent commission of an applicable forcible felony against himself or another. However, the use of deadly force is not justifiable if you find Curtis Reeves initially provoked the use of force against himself, unless A, the force asserted toward Curtis Reeves was so great that he reasonably believed that he was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on Chad Oulson, or B, in good faith, Curtis Reeves withdrew from physical contact with Chad Oulson and clearly indicated to Chad Oulson that he wanted to withdraw and stop the use of deadly force, but Chad Oulson continued to resume the use of force. In deciding whether Curtis Reeves was justified in the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used. The danger facing Curtis Reeves need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. Based upon appearances, Curtis Reeves must have actually believed that the danger was real. If Curtis Reeves was not engaged in an unlawful activity and was attacked in any place where he had a right to be, he had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force, if he reasonably believed that it was necessary to do so to prevent death or great bodily harm to himself or another, or to prevent the commission of a forcible felony. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Curtis Reeves and Chad Oulson. If in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether Curtis Reeves was justified in the use of deadly force, you should find Curtis Reeves not guilty. However, if from the evidence you are convinced beyond a reasonable doubt that Curtis Reeves was not justified in the use of deadly force, you should find him guilty if all the elements of the charge have been proved.
Let's talk about this. We're talking about justifiable use of force. Is anybody familiar with that particular law in Florida? Number 18, I knew that. Pardon me?
Are you talking about standard ground law?
Well, that's kind of the slang, but we're talking about, it's called justifiable use of force, and we'll get to that. I'll get with you, and for the record, your number is 65?
Yes, sir.
Okay. I'm gonna get it right, number 9. All right. Tell me what your studies are regarding the justifiable use of deadly force. And so are you familiar with that particular language?
For the most part, yes, even though it can still be somewhat confusing, I am aware.
Okay, and you study it, tell me why it's confusing to you.
Some of those words can be confusing. Between bigger words, I mean, I guess you could say that, what I call lawyer jargon. But the basis of it, I do understand justifiable force, because we have to have that training because of the situations that we practice.
Okay. If you were chosen on the jury, would you depend on what your knowledge is, or would you go by the law that the court gives you?
The law.
Okay. Anybody else in that first row? I know 18, right?
Yeah, I follow the law.
Okay. Any?
My knowledge is the law.
All right, I understand. The second row, anybody study this subject matter? Third row? Fourth row? Fifth row? And the sixth row, okay, no. Let's talk about a couple of interesting concepts in this justifiable use of deadly force. Number one, the judge told you that the danger facing Curtis Reeves need not have been actual. What do you think of that, number 20?
I think it's a subjective argument, because if in his mind he perceived it to be, then it was a reality to him at that time. And I can think of the situation, hypothetically, to where you're going with your gut instinct in that moment, and you're acting on what you believe to be true. It's not like you've got lit up percentage numbers for objective and subjective arguments above the situation that you're able to confirm. You have to go with what you know.
Okay, so it's not problematic that the law doesn't require that the danger need not be actual. Okay. Number 63. Oh, there you are. Is it problematic for you that the danger need not be actual?
No.
Okay. Number 46?
Your Honor, I'm gonna check, moving further.
The instruction goes on to say, if Curtis Reeves was not engaged in an unlawful activity and was attacked in any place where he had a right to be, he had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force. So let's talk about that. The idea, obviously, is that if a person is abiding by the law, you can read the instruction, that's what it says, and they're attacked in a place they have a right to be, that person does not have to walk away, does not have to leave, does not have to flee cover. You've heard of this before, number 65?
Yes, sir.
You're shaking your head, yes. Is that a problem in row one for anyone, that, hey, if there's trouble, somebody should leave, they shouldn't stay and meet force with force? Anybody in one, is that a problem? Raise your hand. Row two, is that problematic? Is this the right trial for you? Row three, show of hands, you're scratching your head. Okay, row four, row five, row six, show of hands. Okay. Now, if in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether Curtis Reeves was justified in the use of deadly force, you must find Curtis Reeves not guilty. So, what does that mean to you, number 43? Does that mean that Mr. Reeves has to prove anything in this case?
No.
Okay. Does anybody think, because now we're talking about justifiable use of deadly force, that Mr. Reeves is obligated to prove or do anything? Row one, anyone? Hands, row two? Row three? 4? 5? 6? Okay. May I have a moment, Judge? I appreciate your attentiveness. Again, I need the water now instead of Mr. Martin. Appreciate your patience and the hard work you put into answering these questions from your heart. And I don't have any further questions this time. Thank you.
Thank you, Mr. Michaels. And ladies and gentlemen, the questioning is now at an end. The lawyers and myself have some things to talk out with each other, so I'm going to send you to mill about smartly until you're called back. I can't say how long it's going to take, but it's typically, you're probably used to pretty long little things by now, but we're getting close. We're getting very close. So just mill about smartly, and we'll come and get you as soon as we can, okay? And remember my instructions during the recess. Thank you. I need a little bit on your peremptories, but can we at least address the causes? Oh, and I don't know, I'm pretty sure I've told you guys how I do this, but maybe not.
Haven't practiced in front of
Exactly. I do, for peremptories, I do the first 6 to state any challenges, yay or nay, and then say, yes, he does one, then we move the next 6 the same 6 with the new one, to defense, and back and forth, starting with the first row. First row, we keep moving until nobody has any challenges left, or nobody has any challenges, and that'll be our panel. Of course, backstrikes at any time, we'll have to talk about those tomorrow, but tonight, you're fine, any backstrikes tonight.
For the first 6, when you say the first 6, will you give us the numbers of those
Yes.
first 6 so that we can have a record on that?
Yes, absolutely, and that's how it goes. I'll name the numbers, and then we'll move one at a time as strikes are exercised. You both have 1 peremptory per alternate, unless you can announce a lawful basis otherwise. So can we go ahead and do cause, or do we need time to discuss cause?
Do we have 5 minutes?
Sure. Counsel for prosecution have any challenges for cause?
We do, we have juror number 27. When he was discussing reasonable
There's no
doubt.
objection, Your Honor.
Okay, 27. He'll be stricken for cause.
The state does not have any more.
Okay. Defense, challenges for cause of the whole panel?
Yes, Your Honor. Number 26, that was part of that whole discussion regarding
Compared to the football game,
guilt, right?
he
What-
pushed
there
it
they-
pretty hard. I had him as, I thought he would, yeah, any argument, but he definitely went beyond.
I would say it's the way that the question was phrased, and then it was clarified, and he indicated that he would be able to follow up.
Well, he kept saying that no defense makes it easier for the prosecution to win. If push comes to shove, as opposed to not granting when it's been asked, and I heard what I heard, I'm gonna have to go ahead and grant that one.
The next one the defense has is number 77.
I have to agree with that one. He definitely could not, he wanted to hear from both sides, and he said it, he was given the opportunity multiple times. He was explicitly asked, can you follow the law? And he hesitated and said, I guess I could do that. No, I'm going to grant that one. Any others?
No, Your Honor.
Okay. All right, then we'll move to peremptories. Each of you have 10, unless, of course, you can argue a lawful basis for additionals. So the first 6 that we'll consider, I think I've got these all right. Number 2, number 5, number 9, number 13, number 15, and number 18. Out of that first panel of 6, does state have any peremptories?
No, the state accepts.
All right, so that same panel to defense.
Number 18.
Okay. 18 will be stricken by defense. That brings it to number 19, the same 2, 5, 9, 13, 15, 19 to state.
Accept.
Same panel to defense.
Strike 19.
Okay. That's 2. That is to state number 2, 5, 9, 13, 15, 20.
Juror number 20.
Okay. To defense, 2, 5, 9, 13, 15, 29. To defense?
May I have a moment, Your Honor?
You may.
Judge, at 19, we had that we're not striking 19.
Okay. Then, that's okay. Let's see, so, 1, 2, 3, 4, 5, 6, okay. So, I guess that'd unstrike states. You gotta, the panel to state would be 2, 5, 9, 13, 15, 19.
So it's to the state, juror number 9?
You want to strike 9?
Yes, Your Honor.
Okay. So that's actually would be state's first then, since that unstruck state's first. Yeah, unstruck 20. All right, so back to defense, we've got 2, 5, 13, 15, 19, 20.
Accept.
Okay, same panel to state?
My cards were shown 20.
And that'll be your second, okay. Then to defense, 2, 5, 13, 15, 19, and 29.
29.
Okay. That's defense 2. So 2, 5, 13, 15, 19, 31. To state?
Accept.
2, 5, 9, 13, 15.
No, not 9. 2, 5,
5,
13, 15, 19, no, 31. 31, you struck 29.
Who did?
You guys did.
No.
You did.
That was your second strike last time, that's what I wrote down, defense 2, 29. Do you want to unstrike?
It was 19, not 29.
No, Judge, we were Mr. Escobar was discussing that. I asked him.
Struck 29.
Okay.
So what's been struck?
All right, let me unstrike that one. I don't know why I thought I heard that, but,
29 was the last one we just called, right?
No, 31 was the last one we called. Because before that, you struck 29.
okay, let me go back. We've got 2, 5, 13, and it was to defense, right? I mean, state, or was it to state?
State was 9, and I've got
Oh,
20.
Okay, all right. 2, 5, 13, 15, 19, 29. 1, 2, 3, 4, 5, 6. Okay.
Judge, we would strike 29.
Okay. So to defense, it is 2, 5, 13, 15, 19, 31. 1, 2, 3, 4, 5, 6. To defense.
Accept.
Okay. Same panel to state.
Stay with strike for number 15.
Okay. State. I have that down as 4 strikes, 4 state. 1, so that just defense is number 2, number 5, 13, 19, 31, and 33.
Accept.
Okay. Same to state.
That was just a moment ago.
You may.
State accepts.
All right. Then our panel will be number 2, number 5, number 13, number 19, number 31, and number 33. Next, we'll address our first alternate. As I mentioned, each side will get 1 strike unless you can enunciate a lawful basis for an additional. We will be picking 4 alternates. All right, the first one to state, 40,
Accept.
40 to defense,
We'll accept.
okay. That'll be alternate 1, number 40. Number 42 to state,
Judge, we strike 42.
okay. State alternate, that brings it, 43 to defense.
Accept 43, Your Honor, as alternate number 2.
Okay. State, unless you have a lawful basis for an additional, that'll be our alternate 2.
Yes, we're doing 4 strikes for alternates.
1 strike each. You get 1 strike per alternate, that's standard.
No, Colin, 1 strike per alternate, so is that 4?
No, that's
1 strike.
each alternate that we consider, you get 1 strike. That's routine, that's how we always do it.
Well, that is
It's
your
considered,
next 4.
it's because we, so, does the
Then
state
we're
have
out.
it, does the state have any strikes left?
No,
Okay, well, good, we don't have a choice.
right, that's what I was saying, unless you've got a lawful basis for an additional, that'll be our second alternate.
But we can
Okay.
unstrike, correct?
Yes?
So give me the power for a second.
Okay. So 42 to defense.
Accept.
Okay. So she'll be our alternate 2. Number 43 for alternate 3 to state.
You strike 43.
Okay. Number 46 as alternate 3 to defense.
That's for alternate number 3, Your Honor.
Yes.
Accept.
Okay. Uh, 47 as alternate 4 to state.
We're out.
No, you used alternate 3, didn't you?
We struck 43.
Right.
So they're out.
We're out of the game.
No, we're picking a 4th one, aren't we? One,
Yeah,
A,
but they're
one,
saying they're out of
two.
the game is that they can't object.
Right, oh, we have alternate 3 is 46.
Right.
Right.
So we're going to the next one for alternate 4 is 47. You get another, you get 1 strike
They already
per
used it.
alternate.
They used it.
That-
On
maybe-
43.
Maybe that's where we were kind of confused, was how many strikes?
1 per alternate.
Okay, so we,
You've done, you did,
We did 43.
right, that was for alternate 3.
Correct.
So the next choice to defense was alternate, was 46, and they accept, so that's alternate 3. Now we have to decide alternate 4. You get 1, they get 1.
Okay.
Oh.
So we're having 4 strikes for the alternate 4.
No, you get 1 strike for alternate 4.
No, for the group of 4.
No, I'll explain. What the judge is saying is we go through on alternate number 1, you get a strike. If you don't lose it, you don't use it, you lose
Right,
it. You can
right.
look at alternate number 2, you
Right.
get a strike. I never heard
Right.
that before, but I never read directions, I get it now. You understand what's
Right.
going on now?
Yeah, I do now.
Okay,
Sorry.
that's all right. You know, you use it or lose it if you accept, it's just saying, yeah.
Well, so Kevin,
So you can, it's 47 for alternate 4 to state.
Well,
yeah, we were a little bit confused, and maybe
All
it's
right.
me because I was tired.
Do you want to readdress this? We can go right back to where we started from and start all over again to make sure everybody's on the same page. All right, so our panel, we have our panel of 6. You're okay on that. So the first one that was considered for an alternate was 40. 40 to state.
Except,
Okay, you accepted last time. 40 to defense. So if you, so that alternate is done. If you can, you each have the opportunity to strike that one,
Right, so
but,
if we both strike it, now we're back to alternate 1 again.
right,
I got you. Second base.
okay.
I can't guarantee I'm not going to trip, though.
Okay, so state's okay with 40 for alternate 1. How about you guys?
You just want 40, I think you guys said okay on 40.
You did last time, but that's okay. They might not have understood the rules this time. And that's right out of the rules, so one strike per
We'll
alternate.
strike 40.
Okay. So that's defense alternate. So that goes 42 to state. You
The
have,
state strikes 42.
okay. So you've both used your strikes. So that goes, our first alternate will be 43. Unless you have a reason for,
Three now becomes alternate one.
that's correct.
So now we use 43. She's saying no.
All right, let's go through this one more time. You get the first choice. Your first choice, you have one strike for alternate one. So the first choice for alternate one was 40. You said that was okay. First strike to 40, they get a strike if they want, they struck. So your next choice for alternate one is 42. You struck her.
So now
And
43 is.
so you're both out of strikes for alternate one.
Right, so 43 is alternate one.
Correct.
Yeah, I understand.
Okay.
Except we want
We've got alternate one.
Right, no, I know, and I'm gonna apologize, and hope no one snows me. Because it was almost like a repeat of how we did it first time.
That's correct. Does state want
I
to?
think now my tiredness has settled in, and I get it. So I hope no one gets really upset when I say this, but we want to keep 42 and strike 43, which is what we did originally.
Okay, but you don't get to 43 yet.
Okay.
If you want 42, the defense used their strike on 40, so it goes to 42. If you want to keep 42, she will be our alternate one.
Correct, we want to keep her for alternate one.
Okay. You do not want to strike her for alternate one. So. So that brings us for the consideration of alternate two. To first goes to state 43, alternate for the first consideration of alternate two. Does state want to strike 43?
Yes.
Okay. So the next consideration for alternate two is 46. Does defense wish to strike 46 or keep 46? And the state is out of strikes for this one.
I actually knew that. I finally got on.
So by us striking 46, then 47 becomes the alternate two jury.
Bingo.
I'm catching on, Judge.
Okay.
My parents will be happy the law school wasn't a waste. Oh, they didn't pay.
So we're striking 40.
Strike 46.
Okay. All right. So that's defense alternate strike. So 47 is alternate two. All right. Next consideration for alternate three, first to state, is number 50.
State accepts.
Same consideration to defense.
Karen.
As to 50, defense accepts.
Okay. So alternate 3 is 50. Alternate 4 to state, first choice is Robert Rose. Oh. 59. I know.
State accepts.
All right, 59 to defense for alternate 4.
Strike number 59.
Okay. Defense. That brings it to 60 to state for alternate 4. You have a strike left. Yes. You accepted 59, you didn't use any strikes, you have a strike left.
So if we strike, then the next one.
The next one is it, yes.
Mr. Martin meant that as an explanation, not a question, just to be clear. He said we do. He didn't mean to sound insurance. I want the record. All right. Stay with strike 60.
All right. Then our 4th alternate will be Catherine Dahl. Oh, God bless it. Thank you. 63. Thank you. Oh, man. This is killing me. Cows. I need to think of cows. All right, unless someone has a lawful basis for any additionals. So our panel is 2, 5, 13, 19, 31, 33, and our alternates are 42, 47, 50, and 63. All right. Well done, council. Before we bring them back, what's the plan for tomorrow?
That's a good question.
We can at least do openings, right? But then we're on the weekend.
We can do what?
We can at least do openings, even if you don't have any witnesses ready, but then we're on the weekend, Super Bowl Sunday.
Oh, I don't know. I'm too tired.
I know, but that's true. But I'm worried that, yeah, we could. We'd still have 10 days of trial. Go ahead.
Super Bowl, I didn't think about Super Bowl.
Yep.
Back in the old days, when I got married,
Okay.
We've talked about it. I think tomorrow, hopefully, we can do the motions that are outstanding. We can get the stipulations. We have quite a few stipulations that we entered into, if you recall, back at the last hearing in 17.
I think I recall that, yes.
And he has given us the list of Monday witnesses so that
Okay.
obviously we can be prepared. We're going to do that back and forth. In other words,
Okay.
when we're doing our presentation the day before or 2
That's-
days before, whatever, we're going to give them the witnesses that we're going to present.
Okay.
And I guess we can do openings and we've got 1, 2, 3, 4 witnesses that they're going to present on Monday.
I think that's a perfect plan. I would like to start at 9 on Monday, and we'll start at 9 tomorrow, since that's what we're going to do.
Is it real important to start at 9?
I don't want to start at 8:30 on Monday.
I
Can't
was thinking of just a tad,
later?
just a tad.
Because it is Super Bowl. Do you want to start at
You mean
9:30?
Monday or tomorrow?
Monday.
Tomorrow.
Oh,
Oh,
tomorrow. He's talking about
tomorrow's
tomorrow.
fine. Tomorrow's fine. We can start at 9:30 tomorrow,
Yeah.
Okay.
or we can even start at 10. We'll be done. We'll be, we're not going to work till
I know you're
6.
driving all the way, so.
No, I gotta look out.
Oh, you did, okay.
I'm just tired.
I know. You want to do 10?
That's fine.
Let's do 10.
Yeah, 10
You can-
o'clock and we'll,
Okay.
and we work hard till noon.
Right. Well, yeah. Dude, we will not, no. But Monday, 9 o'clock, and after that, we might do 8:30.
I think we should do
Yeah,
8:30, Your
yeah,
Honor.
I think-
This is my fear, and no blame to the court or to anyone. I don't want to be in that third week and be given 3 or 4 days when we have 7 experts
I
and a
gotcha.
battalion of witnesses, and then,
I
we're
know.
being rushed to try to get our presentation. I don't want that to happen. And
Kind of
so,
like me at the other hearing.
so if we can start at 8:30, that would be great.
Yeah, that's what I've been thinking. Then. Tomorrow's 10 o'clock. Monday we'll do 9 because of Super Bowl Sunday. And then thereafter, we'll start at 8:30.
Okay, and I guess we'll.
I'm gonna tell them. I'm gonna tell him, but she can release the other panel go. No, call off the ones for tomorrow. She can definitely do that now, but I'm gonna bring them all back in. All right, so they get the day off tomorrow, and we'll start Monday. Yeah, yeah. You must be a mind reader, Charlene.
I'm so excited. I want to do openings.
Yeah. Oh, good, good, good. Yeah, I don't like to do opening, you know, in a case like this, openings on Friday and then have Super Bowl Sunday in between.
Ready to bring them in?
Yeah. Ready, guys? They're coming. And, oh, one more thing, hold on. I'm not gonna swear them till Monday morning. Okay, okay. Okay. All right, what else?
We're going to gather up all the motions that we think should be heard before opening. We
Okay.
might save some just because.
Okay,
it
I know
applies
we
in
were,
advance.
I know we were gonna do at least one contemporaneous kind of day during the trial.
That was for Mr. Knox.
That's right, that's what I
But
thought.
we were going, we wanted me to pull about the issues on Bedard and Tate.
Yes.
Because,
Yeah.
so we can discuss
Yeah.
them. But I'm thinking, if you want that done tomorrow, I will, but I was thinking that,
You wanna do contemporaneous objections on that, or no?
we need those resolved.
Okay, okay.
You want me to have it ready tomorrow?
I don't care. I don't
I'll
care.
do my best.
If you don't, you don't. I don't care.
I'll get all the other ones done.
That's fine.
Okay.
All right. Okay. Bring them in.
Respect you're in there in the courtroom, Your Honor.
Yep. Is that how they usually sit in here?
yeah.
Okay. Then yes.
they'll come in like that.
Right, right. Yes, that's correct. Let me get Tina,
I can print as many as you want.
can you print one for Tina real quick? They come in down here and they'll go on. Let's skip a few. Let's do one, no, how many can we skip? One, only one?
1, 2, 3, 4, 5, if you're fitting 1, 2, 3, 4, 5, you can only fit one.
Okay,
Okay.
okay, yeah, let's do that and then skip one and then 6, 7, 8, 9, 10. Okay. Or do you want it, we can, no, that's good. Just do,
like that.
yeah, skip one. Okay.
Wait.
Um,
Make sure I'll take this.
Yeah, yeah, you take that one. Okay, yeah.
Yeah, that's fine.
good. Yep,
Okay.
that's good. All right, ladies and gentlemen. I'm about to call the names of those who will be seated on this jury. As I call your name, please come forward and take a seat as directed by the bailiff. I promise you won't be long. And the rest of you I'm going to release just momentarily. All right. Oh, wait, I got to call their numbers. Yes, they're ingrained numbers, probably for the rest of your lives. You heard it so many times this week. Okay, juror number 2, come on down. Juror number 5, follow her if you would. And 13, make your way. "19, follow 13. 31. 33, after him. 42. 47. 50. 63. 63. And you guys are going to be getting new numbers, 1 through 10, so. All right, for the rest of you, I am so appreciative, as is everyone up here, of your time and attention this week. I'm pretty tired, as are we all, but I got to tell you, and this goes for you guys too, sitting here all week watching you selflessly sacrifice your time and go through this pretty difficult process makes me pretty proud to be an American. So I want to thank you sincerely. But you are all now released and discharged from your service as jurors. Just leave your badges and numbers on the bench and you will be free to go. I want to thank you again. All of us sincerely appreciate your time. Thank you, everybody. All right, now just real brief instructions for you guys, and we'll get you on your way as well. I'm just going to repeat the same recess instruction you've heard, I don't know how many dozens of times by now, but absolutely no independent research of any sort. Do not discuss the facts of the case amongst yourselves or with anyone else. Don't watch any news. Don't do any internet looking unless you have someone make sure that this case doesn't pop up anywhere. No YouTube, no nothing that this case could pop up, okay? Anybody have any questions about that? And should you somehow, fall asleep on the couch and the news pops on, let us know right away. Shut it off, but let us know right away, okay? And that's going to apply throughout the trial. Obviously, we had to go through all the publicity stuff, so I don't want to spoil it now or any point during the trial, so please be very careful about that. Don't let anybody talk to you about the case, and, just be real strict about that. All right, so I'm gonna give you tomorrow off, and we're gonna start Monday morning, 9 o'clock. I know it's Super Bowl Sunday, but 9 o'clock on Monday, if you'll be back to the jury pool room, and But after that, we're probably going to start at 8:30, okay? That'll be our normal starting hours. I'm going to give you a little breather on Monday, but after that, our hours will typically be 8:30 to 5. I'll have much better control over our timing. We all can work together on that. There may be times when you finish a little early, probably not, but there may be times when we go a little late. But it won't be like this has been. And I'll be able to tell you, you'll be able to tell probably where we're at with a witness or whatnot. So that's going to be our typical routine. And this we'll have next week and the following week is the length of this trial. So let's see. Any questions about that? Let's see, what are you?
Number 3 now.
No, she's number 7. She should be number 7.
2 grades there, ma'am.
Oh, okay, oh, sorry.
I'm sorry,
1,
yes.
2, 3, she would be,
Yes.
that, in the
3
front
and
is
7.
3, yes.
6 of us are on the jury, 4 of us are alternates, correct?
Correct, that's the way it works.
Okay. Who is the 6th?
We're not, that's not, no.
Oh, okay, I didn't know.
You'll all find out at the appropriate time. All right, number 3, or did,
Is there a different printout we need to obtain to provide our employers to show that we're going to the next 2 weeks?
I don't know, do you have a letter for that? If not, I can get you one from my office. But yeah, I don't think I can do that now. Do you need it now?
No,
Okay. I'll have my assistant print some up. How many of you do you think would need one of those? 1, 2, 3, 4, 5, 6. Yeah, you got a new number. 6 of you? Okay. All right, I think I got 6. Once I have, yeah, once I get the letter typed up, I can get it ready for as many as you need.
We'll get one for-
I'll have it
Have
tomorrow, but you won't be here till Monday, so you will have it Monday.
Is that good for everybody? Okay.
All right.
You need one for tonight?
You would be,
No, 47.
7,
You need it
8.
for today.
You're number 8.
Okay, just wondering, I have a part-time job, if I'm scheduled tomorrow or on the weekend, is it okay if I go to work?
Tomorrow and the weekend, you're fine. But after that, we need you Monday through Friday, okay? For the next 2 weeks. All right. Anybody, any other questions
We can get a letter
for today?
for today.
Yes.
They can go get
Yes.
the letters.
Yes, you can go get letters for today in the jury pool room from Kaylee, I guess is still in there. Tammy's in there. All right. And this is where we'll be working, but you, at all times, every time after a recess or a break, always report to the jury pool room. Don't ever just walk into the courtroom, because chances are we're working in here, and if you're not here, then we're doing things that we have to do outside your presence. So that's how that works. So always report to the jury pool room, and remember, I know I instructed you, but part of the instruction is that you can't talk about the case amongst yourselves. And the only time you'll be able to do that even is when you start your deliberations, okay? I'll instruct you Monday more when you come back, but I just want you to know that that's how that works. Even amongst yourselves, you can't talk until you're in the deliberation room. All right? Any other questions? Thoughts?
I have one.
Number 4?
How or will we be protected from meeting?
We have a procedure for that. We're talking about it for the final day. I think I would imagine they better not be talking to you now, or they.
Well, let me rephrase my question. I guess I mean, so far as them taking photos.
They're not allowed to take photos of you now, or really ever if you don't want that. Once you're discharged, it'll be up to you to decide if you want to talk to anybody or not, and that's a standard instruction. And we do have a procedure in place, so you don't have to deal with any of that when you've reached your verdict and you've been discharged. We'll have you park in another area and take you straight there. Okay?
Coming to here every day, and we still come through
Yeah.
the work,
Yeah.
normal process.
Yes. But the media is under strict rules to not ever take your picture or identify you in any manner. So should that happen, they will, they'd lose their privileges probably across the country. So they know better than to do that. All right, any other questions or concerns? So I won't see you again until Monday morning at 9 o'clock, all right? Thank you all very much. It's been a long week, I know. 9 on Monday. Yeah, because of Super Bowl. Hey, can you tell them they'll have pens and papers if they want to take notes? Sorry. They'll be provided. They don't have to bring them. All right. Any matters we need to address right now? All of you, thank you very much. That was a long week, and you guys all worked together. Thank you. Good job. And I'll see you all at 10 o'clock tomorrow morning.